once we get going, with a couple of exceptions there, we're going to go straight through from, I'm sorry, I have a message here that I don't really need, but we're going to go straight through from opening statement to closing argument with no breaks. The exceptions are, one, if there is a health emergency, we will, of course, suspend proceedings to take care of that. Please let me know if something like that comes up. The second thing is that as a matter of my practice, I have breaks between the segments of the trial, such as between the opening statement and the first witness. That is to allow the scoring panelists the opportunity to complete their score sheets and then provide complete attention to the proceedings before them. Scoring panelists, I'm going to ask you that when you have completed that section, each section of the score sheet, to give me some kind of sign, either verbally or orally, so that verbally or visually, so that I can proceed with the trial. I guess as long as I'm talking about myself, I'll let you know my name is Randy Livingston. My background is that I practiced law in Colorado, in Denver, for 35 years in civil litigation, handled a lot of trials in the state of Colorado. I've been working with mock trial as a presiding judge for probably a decade, so I'm used to these things and enjoy the presentations that you folks put on each year, and I'm happy and eager to see what you guys do with this problem this time. As you know, the rules of the competition provide that disputes regarding the rules are to be decided when they can't be decided in trial under the rules by the competition committee. Now, I assume that we have two timekeepers, one for each team. Is that correct?
Yes, Your
We
Honor.
have Mr. Horowitz for Meredith and for Stanley.
Yes, Your Honor.
Okay. How are you guys going to keep us apprised of the available time?
I am planning on posting time in the chat in minute increments for my time or for my team, and communicating with opposing counsel's timekeeper at the end of each segment.
Same here. I will be posting 5-minute increments until the last 5 minutes, and then 1-minute increments.
Okay, and you're going to use the chat function?
Yes, Your Honor.
Okay, and I think you seem to have worked out that you're going to do it one at a time and then confer at the end of the segment to make sure that you're more or less agreeing with what the time remaining is.
Yes, Your Honor.
Meaning that there's only going to be one posting during each segment.
Yes, Your Honor.
Okay. I will be enforcing the time requirements rigorously, so you should make sure that you are keeping within the time allotted.
Your Honor,
At this point,
it's my understanding that they've emailed the stuff and we are good to start.
Okay. Scoring panelists, do you have the rosters? Good. All right. At this point, I would like each team, starting with Team Meredith, to introduce the team members to the scoring panelists. Meredith?
Good morning, Your Honor, opposing counsel, members of the jury. My name is Annabelle Eisner. I will be delivering the opening statement for the plaintiff, conducting the direct examination of Dakota Weirs, and conducting the cross-examination of Blake Doncourt.
Thank you.
Good morning. My name is John Wiley. I'll be conducting the direct examination of Dr. Casey Rogers and the cross-examination of Dr. Devin Williams.
Thank you.
Morning. My name is Kylis Abbott. I will be conducting the direct examination of Carson Durst, the cross-examination of Skylar Weirs, and delivering the closing argument on behalf of the plaintiff. May our witnesses and timekeeper now introduce themselves?
Please do.
Good morning. My name is Felix Feiger, and I am Dakota Weirs.
Good morning. My name is Ellie Musfelt, and I am Dr. Casey Rogers.
Good morning. My name is Aya Margalit, and I'm Carson Durst.
Good morning. My name is Kobe Horowitz, and I am the timekeeper.
Thank you very much. Dr. Rogers, you were very faint on your microphone. You may want to adjust your volume. Okay, thank you very much. Team Stanley.
Good morning, Your Honor. My name is Caitlin Brennan, and together with my co-counsel, we represent the defendant, Lush Fertilizer Incorporated. I will be presenting the opening statement, conducting the cross-examination of Dakota Weirs, and the direct examination of Blake Doncourt.
Good morning, Your Honor. My name is Angel Hernandez. I'll be conducting the cross-examination of Carson Durst, the direct examination of Dr. Devin Williams.
Good morning, Your Honor. My name is Bailey Burton. I will be conducting the cross-examination of Dr. Rogers, the direct examination of Skylar Weirs, and presenting the closing argument. May our witnesses now introduce themselves?
Yes, they may.
Good morning, Your Honor. My name is Hannah Feeney, and I am Dr. Devin Williams.
Good morning, Your Honor. My name is Mason McCarty, and I am Skylar Weirs.
Good morning, Your Honor. My name is Marcus Winton, and I am Blake Doncourt.
Thank you. Now, among the procedures that the committee requests is that the participants in the competition have themselves sworn in before the beginning of each round. As a reminder that one of the purposes of this competition is to develop a sense of regular procedure and fair play and respect for the rules of the competition. So in that case, I'm going to ask all of the team members to raise their right hands. Team members, do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
And witnesses, keep your hands raised. Do you promise that the testimony you're about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition?
Yes,
Yes, Your Honor.
Thank you. Scoring panelists, please raise your right hands. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition?
Yes, Your Honor.
I do.
Yes, Your Honor.
Thank you. Now, are there preliminary matters that the teams would like to bring before the court before we get going?
Yes, Your Honor. The plaintiff has a few preliminary matters.
All right.
First of all, we hope that this does not happen, but in the unlikely event that there are major technical issues, and for example, one of our team members or a team member for the opposing counsel gets kicked off of this Zoom meeting, we would ask permission for that team member to contact their teammates via text message in order to rejoin the Zoom call.
Is there any objection from Team Stanley?
As long as the text message is only related to the technical difficulties, we have no objection.
All right, then that is permitted.
Secondly, Your Honor, we would like to recognize that there are two Weirs twins in this case, and we would like to ask the court permission to call them by their full names as opposed to simply their last names. We mean no disrespect to either of these individuals. We are merely trying to make things clear for the jury.
That's fine.
And finally,
Andy?
Your Honor, excuse me.
Go ahead.
Yes, Your Honor. Finally, we would like to ask that any remaining time at the end of our closing argument be reserved for rebuttal.
That will be granted.
Yes, Your Honor. That is all.
All right, thank you. Team Stanley, do you have any preliminary matters?
Yes, Your Honor. We would like to remind the court and the scoring panelists to put their Zoom settings into gallery view rather than speaker view. This will allow them to see our presentation both screens instead of just one, as our audio is only routed through one computer rather than both.
I don't know if the scoring panelists understood what you said. I certainly didn't. What are you asking us to do?
There is a video setting in Zoom that allows you to put it in gallery view, which means you can see everyone instead of just the person that is talking. And we prefer that you put your settings in that mode instead of in speaker view so that you can see our performance at all times.
Well, I'm not going to dictate to the scoring panelists how they want to watch this. So I'm not going to grant that motion.
Yes, Your Honor, I was just making you aware of our situation today.
That's fine.
We request permission for Blake Doncourt, the CEO of Lush Fertilizer, to be our advisory witness and to be seated at counsel table for the duration of trial.
That's granted.
For the record, all witnesses will be present today and not sequestered pursuant to Rule 5.3.1 of the Rules of Competition.
Well, yes, that sequestration is not allowed without a court order. Go ahead.
May my trial technician provide a copy of the stipulations, jury instructions, and the court's pretrial ruling to the court via the Zoom direct message feature?
The scoring panelists and I have copies of the case problem. And in that instance, we have those documents.
Yes, Your Honor. At this time, I would like to enter an additional stipulation. We would like to stipulate.
Go ahead.
We would like to stipulate to the admission of Exhibit 1.
Team Meredith, Ms. Eisner.
Your Honor, Team Meredith would request that all exhibits be properly authenticated and confirmed by both parties in trial before they are admitted into evidence. So we would object to this request.
May I respond to that?
Well, there being an objection, there is no stipulation. A stipulation is an agreement and the other side doesn't agree. So there's no response needed.
Yes, Your Honor. Can the court clarify whether it intends to constructively read the jury instructions to the jury before or after closing arguments?
The court, as a matter of practice, reads the jury instructions before the closing argument.
Yes, Your Honor. And prior to trial, we would like to verify a few of the procedures of this online trial. Pursuant to Rule 7.4 of the Rules of Competition, all witnesses should have copies of all of the exhibits and their own affidavit in front of them so that both counsel can question witnesses on those exhibits without displaying them on the screen so they are outside the view of the jury.
Team Meredith, what is your position on that?
Your Honor, we have no objection to witnesses having copies of their affidavits or of the exhibits in their possession. However, we would ask for clarity's sake that exhibits are in fact screen shared in order to make things clear and faster, and also so that opposing counsel is able to verify what is being entered.
Okay. First, I'll ask the scoring panelists, do you all have copies of the exhibits?
I do, Your Honor.
Mr. Lambert?
Yes,
Your
Honor.
Do you have copies of the exhibits?
I do, Your Honor.
All right, thank you. And Ms. Moss, do you have copies of the exhibits?
Yes, Your Honor.
All right, thank you. So everybody has copies of the exhibits. I guess what I'll say is that we will deem that the jury does not look at the exhibits until such time as they have been entered into evidence. For the rest of your request, it's my understanding that the witnesses all have copies of the exhibits and therefore can be questioned about the exhibits when laying a predicate for their admission. Is there a problem that Team Stanley has with publishing the exhibit on the screen to allow people to follow the questioning as it occurs?
Your Honor, we intend to publish the exhibits to the screen after they have been admitted. We simply didn't want to share them on the screen prior to admission.
Okay, that's what I thought you were saying. I don't see that there's a problem if people want to put the exhibit on the screen while it's being questioned, because we are dealing with a deemed reality in this instance anyway. We are pretending that people don't see that when they have already seen them. So I think you can, if you don't want to put it on, although I would recommend it would be easier for everybody to follow what the questioning is if they are visible. But if you don't want to put them on, you don't have to put them on until they're published and admitted and published. If I will not be entertaining objections to Team Meredith putting them on if that's what they want to do.
Yes, Your Honor, if you prefer that we share exhibits to lay foundation for their admission, we can do that as well.
All right. It's entirely up to you.
Yes, Your Honor. Finally, we ask for permission to move about our well during speeches and examinations.
During closing and opening, the lawyer presenting that segment of the trial is free to move around the well. If this were not a virtual trial, I would tell an examining witness that they can move, but they can't, but they have to stay within arm's length of the podium. In this instance, that doesn't really make much sense. However, I would advise you that since you're doing this on camera, if you move around too much, it's going to be hard for people to see who you are and what you're doing, and it will be distracting to them. So that, again, is up to you. But how you want to present it is your decision.
Yes, Your Honor. To clarify, are we permitted to use the well during examinations as long as we do not approach the witness too closely?
You may use the well, yes.
Yes, Your Honor. At this time, we are ready to proceed to trial.
All right. Team Meredith, are you ready?
Pardon me. Yes, Your Honor. We're ready to proceed to trial.
All right. Then we shall get going, and Team Meredith, you may make your opening statement.
Good morning, Your Honor, members of the jury. Today, you will hear about a company that put profits before people, causing a young man to suffer immensely. That young man is named Dakota Weirs, and after working for several years with a Lush fertilizer product, he has developed an incurable type of cancer known as non-Hodgkin lymphoma. As the evidence today will show you, this Lush fertilizer product that he worked with was the sole cause of his disease. In fact, this product was poorly labeled, poorly prepared, and contained ingredients, namely a chemical known as Drufo, that had been shown to be carcinogenic. Furthermore, the plaintiff took no risks outside of his landscaping work, and he worked with no other products that contained the chemical Drufo. Mr. Weirs has suffered and continues to suffer greatly from this disease, and he is seeking non-economic damages from the defendant. My name is Annabelle Eisner, and I, along with my co-counsel, John Miley and Kylis Abbott, represent the plaintiff, Dakota Weirs. This is a case about a young man whose life has been ruined through no fault of his own. It is a case about a company's negligence and disregard for users' safety. Today, you will hear the many ways that Lush Fertilizer failed to safeguard against potential risks of their product, from ignoring studies skipping key preparation steps. As the plaintiff in this case, we will be proving 4 key things for you today. First, that the defendant did manufacture a product containing the chemical Drufo. Second, that the defendant's negligence made this product hazardous even for reasonable users. Third, that the plaintiff was one such reasonable user. And fourth, that the damages to the plaintiff were caused by the defendant's negligence. To prove these things, we will be calling 3 different witnesses to the stand today. First, you will hear from the plaintiff, Dakota Weirs. He will tell you about how non-Hodgkin lymphoma has upended his life and ruined his prospects for the future. He will also testify to the poor labeling of the product that he worked with, as well as his concern over its ingredient, Drufo. Then you will hear from Dr. Casey Rogers, a professor of horticulture and entomology at the University of California, Berkeley. She has a PhD in agriculture and entomology and a bachelor's degree in agriculture and chemistry. Dr. Rogers has been studying the effects of toxins on the human body for years, and she has discovered that Drufo causes a much higher incidence of non-Hodgkin lymphoma in people exposed to it on a daily basis than in those who don't interact with it. Last, Carson Durst, a former Lush Fertilizer employee, will take the stand. She will testify to the negligence that she witnessed firsthand in the testing of Drufo, including blatant disregard for a study that linked the chemical to non-Hodgkin lymphoma. Now, the defense will try to convince you that their product was not the cause of the plaintiff's cancer, but they'll rely on speculation to back up this claim. They'll call the CEO of Lush Fertilizer to the stand. We expect will try to tell you that their product is completely safe and cannot have caused anyone cancer. But listen carefully, and you'll also hear him admit that Lush Fertilizer did not take every precaution to ensure that their product was safe for users. In fact, they could not even be bothered to take the simple step of putting their product in an oven and baking it, a precaution that would have removed any risk of the product being carcinogenic, just because they thought that it was too expensive. Today, you will also hear from Skylar Weirs, who will likely tell you about the many benefits of Drufo. But keep in mind that Ms. Weirs does not have a college degree and has been known to write articles about UFOs and other conspiracy theories. You will also hear from Dr. Devin Williams. We expect will try to tell you about the ecological benefits of Drufo. But listen carefully, and you'll hear him tell you that Lush Fertilizer did not protest when their product was banned in the entire EU, just because they thought that this was too expensive. All of this evidence will show you that Lush Fertilizer is willing to take shortcuts to protect their profits. By the end of the trial, we will have proven, by preponderance of the evidence, that the defendant's negligence was the sole cause of the plaintiff's cancer. Members of the jury, all these reasons are why, at the end of the trial, we will ask you to require Lush Fertilizer to fairly compensate the plaintiff for his suffering. We will ask you to hold the defendant accountable for their negligence, to hold them accountable for the plaintiff's pain, and to hold them accountable for his destroyed future. Thank you.
Thank you. The defense may present its opening argument, opening statement.
Yes, Your Honor. Before I begin, may I have a moment to clear the live stream message from our screen?
Yes.
May it please the court? Misguided, misinformed, and misused. We're here today because unfortunately, Mr. Weirs has a type of cancer called non-Hodgkin's lymphoma. Many of you probably know how heartbreaking it is to hear news of a friend or family member's cancer, or have even experienced it yourself. And so it's not surprising that Mr. Weirs is now looking for answers. Why him? Why now? And what caused this debilitating disease? But this misguided lawsuit was fueled by misinformation and Dakota's misuse of the products he worked with while at Haven Landscaping. Misguided, misinformed, and misused. Lush Fertilizer Incorporated is a fertilizer manufacturer. For the last 20 years, they have truly been helping to make the world a better place. Their CEO and founder, Lush Blake Doncourt, will tell you how Lush was created as and is a safer and healthier alternative than other mainstream fertilizers. He will tell you that Lush followed all of the necessary precautions to ensure their customers' safety, including placing a warning label on the packaging of their product. Skylar Weirs, the plaintiff's own twin brother, will tell you how Dakota didn't wear the proper protective equipment while at Haven Landscaping. Despite being a child at the time of his employment, Dakota worked with chemicals that were clearly marked "keep out of reach of children." Despite being instructed to wear an N95 face mask or respirator, Dakota didn't wear one. And despite being instructed to wear protective clothing that covers exposed skin, Dakota chose not to. Somehow, out of all of the harmful chemicals he worked with at Haven Landscaping, he chose to blame Lush Fertilizer, the one product that was created as a safe alternative to the others. Lush Fertilizer can't be responsible for Mr. Weir's cancer because Lush Fertilizer is safe. Dr. Devin Williams, a toxicology researcher, will tell you all about that. At the end of the day, Haven Landscaping is responsible for employing a child to work with dangerous chemicals and for not monitoring their employees to ensure that they were wearing the proper protective equipment. At the end of the day, Haven Landscaping and the companies that manufactured those other dangerous chemicals should be on trial today, not Lush Fertilizer. Now, both parties have the burden of proof in today's case. This means that there are two steps when it comes to reaching your verdict today. First, the plaintiff must prove by a preponderance of the evidence, which means that it's more likely than not that Lush Fertilizer failed to exercise reasonable care with their product. Within that, Lush had to know that their product was dangerous and know that any risk associated with the use of that product was not obvious to the average user. If you do find that Lush was negligent, you must also consider whether or not Mr. Weir's cancer was partially or even fully a result of his own misuse of the products he worked with. We are confident, though, that at the end of today's case, you will see that Lush Fertilizer is in no way responsible for Mr. Weir's cancer. As you listen to the evidence today, I want you to ask yourself these three questions. First, did Lush Fertilizer fail to exercise reasonable care with their product? Second, could Lush Fertilizer really have expected that a mere 14-year-old child would be working with their product? And third, could Lush really have expected that a consumer like Dakota Weirs would not use the explicitly recommended protective equipment? If you can answer any one of those questions with a no at the end of today's case, the plaintiff has failed to meet their burden, and you must find in favor of the defense. The plaintiff told you today that this case is about profits over people. But you will hear that Lush Fertilizer prioritized the safety of their customers over everything else. You will hear that if anyone put profits over people, it was Haven Landscaping and the other companies that manufactured the chemicals that Dakota worked with. As sympathetic to Dakota's cause as you might be, you cannot let that sympathy influence your decision today. This case was misguided, misinformed, and misused. At the end of today's case, my co-counsel, Ms. Burton, will ask you to return the only just verdict of not liable. Thank you.
Thank you. We'll pause now while the scoring judges complete their score sheets.
I have finished, Your Honor.
Same here. Your Honor.
I finished, Your Honor.
All right, thank you. The plaintiff may call its first witness.
The plaintiff calls Dakota Weirs.
I'll remind Mr. Weirs that he remains under the oath he took at the beginning of these proceedings.
Yes, Your Honor.
Good morning, Mr. Weirs. Would you please introduce yourself to the jury?
Good morning. My name is Dakota Weirs.
And why are you here today?
I've been diagnosed with non-Hodgkin lymphoma. I believe that lush fertilizer is the sole cause of my disease.
And what is
Your Honor, may I be heard?
I didn't hear the objection.
Yes, Your Honor. I object. This is an improper expert testimony pursuant to Rule 702. The witness testified that he has been diagnosed with non-Hodgkin lymphoma, which he cannot do as he is, has not been qualified as an expert in any sort of medical field. In addition, if he's testifying about a statement that has been made that is hearsay pursuant to Rule 801.
If I may respond,
Ms.
Your Honor.
Eisner?
Mr. Weirs has been diagnosed by this cancer. His understanding is that he has been diagnosed with this specific type of cancer, which he will definitely have enough personal knowledge to know, as he is the one who is suffering from this disease and who has endured so many doctor's visits to get treatment for this disease. It is a personal condition of his, and thus he has more than enough personal knowledge to testify to what disease he has.
Ms. Brennan?
Yes, Your Honor. My objection was not to personal knowledge, however, to the expert opinion that is being elicited about the diagnosis. If opposing counsel is saying that they have enough knowledge to know about that diagnosis, the diagnosis itself is still hearsay for Rule 801, as it is an out-of-court statement being used to prove the truth of the matter asserted. The truth being that Dakota Weirs does in fact have non-Hodgkin's lymphoma specifically. That statement would be by the doctor.
Ms. Eisner?
It is a known fact in today's case that Mr. Weirs has cancer. That is not a disputed fact in this case. And as he is the one suffering from this cancer, it is not hearsay for him to specifically say what kind of cancer it is that he has. He knows what kind of cancer he has. He has suffered this kind of cancer. He would have more than enough knowledge. This is not hearsay that he would know what kind of cancer he has.
May I respond, Your Honor?
No, you may not. I think I've heard enough. First, as to the expert witness objection, the witness has not been asked whether he diagnosed himself with the cancer, and therefore it's not a matter of expert opinion, and he doesn't have to be qualified as an expert to testify to his physical condition. Secondly, under Rule 803(4), I guess I would like to ask you, Ms. Brennan, why the statement implied, at least to the witness, is not a statement regarding medical condition, which is an exception to the hearsay rule.
Your Honor, the exception under Rule 803(4) regards statements made for diagnosis or treatment. This would be statements made by Dakota Weirs, such as explaining symptoms, not statements by the doctor regarding a specific diagnosis.
Well, I think under Rule 803(4)(a) and B, the statement made for and is reasonably pertinent to medical diagnosis or treatment, or describes a medical history, is something that the witness can testify to as an exception to the hearsay rule. Therefore, the objection is overruled.
Yes, Your Honor.
Mr. Weirs, why are you here today?
I've been diagnosed with non-Hodgkin lymphoma. I believe lush fertilizer is the cause of my disease.
And what is non-Hodgkin lymphoma?
It's incurable cancer.
Mr. Weirs, I'd like to start by talking about your background. Could you tell the jury a little bit about yourself?
I'm 20 years old. Before I was sick, I used to do it all. I was part of the National Honor Society, president of my student government. I volunteered, but really above all that, I had a passion, a burning passion for playing the piano.
Can you tell us more about your passion for the piano?
It was ever since I was a child. I remember my grandpa playing on the piano, and he was inspirational. And I picked it up, and I got real good. I got really good. Got good enough to get a full ride scholarship to the college of my dreams, Juilliard. But
Objection, Your Honor, may I be heard?
Yes.
This is more prejudicial than probative and not relevant pursuant to Rules 403 and 401. Pursuant to your pretrial ruling, only non-economic damages are at issue in today's case. The witness is talking about a scholarship he received to Juilliard, and this can only serve to prejudice the jury in Mr. Weir's favor.
If I may respond, Your Honor.
Yes. Go ahead.
Whether this loss of a college scholarship is absolutely relevant for non-economic damages, not only because of the way that it has destroyed and derailed Mr. Weir's prospects for the future, but also because of the emotional toll that all of these things must have taken on him, including losing his passion for the piano, which he has already attested was very important to him. Therefore, all of this evidence does go towards non-economic damages.
Ms. Brennan?
Yes, Your Honor. The witness can talk about the impact that not going to college has had, or even the impact that not going to Juilliard has had. However, straying into the realm of talking about a scholarship from Juilliard goes solely towards economic damages.
Well, I have to disagree with that because part of the claim, as I understand it, is that there is a loss of quality of life for his inability to continue to practice or play the piano, while a scholarship to Juilliard would have some economic impact to him. I think the fact that he has received a scholarship to Juilliard is an indication of his ability and his talent, and therefore the importance of playing the piano is to him. So I think it goes to non-economic damages, and it's something that the jury is permitted to hear. So overruled.
Yes, Your Honor. I ask that a limiting instruction be placed on the jury so that they can only consider it for non-economic damages.
Denied.
Mr. Rears, would you please continue telling us about your passion for the piano?
it was my last connection to my grandpa. Really, that's what it was. Every time I would sit on that bench and play, I felt like he was right there next to me. But I can't play anymore, and it feels like I lost him a second time.
And Mr. Rears, when you weren't pursuing your passions, did you have a job?
I worked for Havens Landscaping. They were a local business.
I'd like to talk more about your work in landscaping. How old were you when you began that job?
I was 14 years old when I started working for them.
And what sort of work did you do at Haven Landscaping?
Because I was really young, I wasn't old enough to work with some of the bigger equipment like the aerator or weed whacker. And so it was mostly just countless hours on my hands and knees spreading seed and fertilizer.
And what products did you use?
I used an array of chemicals and fertilizers, but I especially remember using Lush fertilizer.
And what precautions were you instructed to take when you were using these products?
The official rule was to wear gloves, long sleeves, and a mask, but for the conditions, those weren't always really realistic at all.
Why weren't these rules realistic?
In the summer, it got too hot to always wear all those layers and coverings. The other part, I was 14 years old. I was just following what everyone else was doing.
Mr. Rears, at this time, I'd like to ask you to refer to your copy of what has been marked as Exhibit 1.
Yes.
What is Exhibit 1?
It's a photograph of the Lush fertilizer label from my boss at Haven.
And how did you obtain this photograph?
The moment I found out that Lush could be toxic, I immediately called up my boss and asked him to send me a photo.
And is this a product that you worked with?
Yes, it is, every day.
Is this a complete and accurate copy of the photograph your boss sent you?
Yes, it is.
Your Honor, I move to enter Exhibit 1 into evidence.
Your Honor, I believe you're muted.
Is there an objection to the admission of Exhibit 1?
As I plan to use this exhibit during my cross-examination, I have no objection.
Then Exhibit 1 is admitted.
Permission for co-counsel to publish via screen sharing.
Granted.
Mr. Weirs, to your knowledge, is there anything unique about Lush fertilizer?
If you look under the active ingredients list, there's a chemical called Drufo.
And have you done any research on Drufo?
Yeah, yes, I have. Drufo is banned all across the world. It's banned in Canada. It's banned in the Congo. It's basically banned in the entire EU.
Objection, Your Honor, may I be heard?
What's your objection?
This is hearsay pursuant to Rule 801, as it is an out-of-court statement being used to prove the truth of the matter asserted. The truth being that Drufo is in fact banned in the EU.
Response, Your Honor?
Ms. Eisner?
This is not an out-of-court statement. Mr. Weirs is simply testifying to his own personal knowledge of Drufo based on the research that he has already said he has done.
Well, is his reach, what is his research? Has that been established?
We have not established what research he has done. However, it has been established that he has done research and also he has worked with this product. So he should have sufficient experience and knowledge of this product and the other products that he worked with to know what Drufo is and things about it.
Well, how is working with Drufo providing hypnologists the status of Drufo as a banned substance in the Congo or the EU?
Because he has worked with Drufo, he has also looked into Drufo because he already knew what it was, and that has allowed him to do research on the ingredient and to discover where it is banned.
Well, by doing research, you mean he's looked at documents or web pages outside of court. Isn't that correct?
Yes, it is correct, but he also has personal knowledge of these things at this point in the trial.
He has personal knowledge of things that he has read. That's all you're saying, isn't it?
And additionally, this ingredient is not relevant is not being entered for the truth of the matter asserted. It goes towards his state of mind, because if he thinks that this product was banned, then this would show why he is pursuing Lush fertilizer in court today.
Ms. Brennan, do you have a response to that, please?
Your Honor, this can only be used for the truth of the matter asserted. The effect on the listener can be elicited without saying that Drufo has been banned in other countries.
Your Honor, I disagree. I believe that this information is relevant to the truth, to not the truth of the matter asserted, but the effect on the listener, as it will change their point of view whether or not this product has been banned.
Well, I would suggest that the subjective belief of the witness is not really relevant to proving the negligence of the defendant. And I don't see how information gleaned from reading something outside of court can be anything other than hearsay. Therefore, the objection is sustained.
Your Honor, I move to strike the testimony.
The objection has been sustained, and I think that's sufficient. Thank you.
Mr. Weirs, are there any warnings on this product?
Warnings? There are no warnings of non-Hodgkin lymphoma, of cancer, of what I go through and what I wake up with every day. There's recommendations that say the product can cause eye irritation. Nothing about cancer at all.
Mr. Weirs, now I'd just like to talk briefly about some of the other products that you've worked with. Did those products have warnings on them?
Other products have clear, specific, laid out warnings that are meant to help the user.
Now that we've discussed the origins of this disease, I'd like to talk about how it has affected you and the people that you care about. First of all, has this disease impacted your relationships with your family?
Tensions have risen a lot. My dad now has to shoulder my medical bills along with my twins' gambling debts. It's stretching him really thin.
And has your relationship with your twin Skylar changed since you contracted this disease?
We were never close by any measure, but it seems to me like Skylar's mad at me, like Skylar's mad at my disease, and I never expected Skylar to testify against me.
What issues have you and Skylar had in the past?
We're twins. We've had issues. Skylar's an amazing journalist, but I don't like how Skylar uses his journalism skills to write about all these absurd issues like UFOs, flat earth theory. It's crazy.
Objection, Your Honor. May I be heard?
You don't ask to be heard. You're making the objection. Go ahead.
Yes, Your Honor. This is improper character evidence pursuant to Rule 404A. The witness testified that they don't like how Skylar is using their skills to write about absurd theories. This is showing that Skylar has a character trait for writing conspiracy theories, and that he would have acted in accordance with that character trait in today's case when writing about Truffaut, which is improper.
Ms. Eisner?
This evidence is not showing that Skylar is conforming to a character trait. It is Dakota's opinion of Skylar's writing, as well as showing potential bias that Mr. Rears might have against his twin, which is absolutely relevant since he is testifying today in court. As well, I believe that Mr. Rears is going to be entered as an expert witness today, and showing any bias that an expert witness may have or casting doubt on an expert's testimony is in fact admissible.
Ms. Brennan?
That testimony is admissible when it is not in violation of one of the rules of evidence, which this testimony is. This is still talking about a character trait of Skylar Weir's, showing that he acted in accordance with that character trait of writing conspiracy theories and or being untruthful.
In fact, there is an acceptance to character evidence that states that it can be used to prove a witness's truthfulness.
Okay, I think that I don't think that the question asks for a character trait. It asks for a description of the kinds of writings that the potential witness engages in. I think that Ms. Eisner is correct that the probable value of the kinds of writings that the potential witness engages in is something that the jury can consider when the jury is evaluating the credibility or the weight to give to the testimony that is going to be ostensibly presented during the defense case. Therefore, the objection is overruled.
Mr. Rears, would you just repeat what you said about the articles that your twin writes?
Skylar will write anything for the right price. She'll write about UFOs. She'll write about flat earth theory. She'll write about anti-vax culture. She'll write about chemtrails. It's absurd.
Now I'd like to talk about how this disease has affected you personally. First of all, what are some of the symptoms that you've experienced?
I'm exhausted. I'm fatigued. I'm tired. I'm out of breath. I can't sit on hard surfaces. It leaves bruises. I'm weak. My abdomen will swell to double its size, but at the same time, I'm suffering from weight loss. It's awful.
What changes have you had to make to your lifestyle?
I can't do anything physically demanding at all. I can't play the piano. I can't hang out with my friends. I'm either at the doctor's office or just sitting on my couch watching TV. Instead of living out my life in college with my friends playing the piano, I'm living my life out in the doctor's office.
And Mr. Weirs, has that affected your mental health?
I have bouts of depression, but again, the worst part of this has been I lost my pride and joy in life, the piano.
Mr. Weirs, I would now just like to briefly talk about life looking forward for you. How has this disease changed your outlook on life?
I'm mad at Lush. I feel like my life is ruined. My doctors are unsure of the treatments I might need. Frankly, though, it's become less about the piano or the college of my dreams, and more about just making it to tomorrow, because I'm terrified. I'm terrified that every single day will be my last.
Thank you. No further questions at this time.
All right, thank you. Ms. Brennan, you have cross-examination.
Yes, Your Honor. May I proceed?
Yes, you may.
Mr. Weirs, I understand you're working through a debilitating disease right now, but I do have to ask you a few questions. Now, your brother is a journalist, right?
Yes.
He's testifying against you today?
Yes, he is.
In fact, you think his research and writing skills are formidable, don't you?
Skylar's an amazing journalist. It pains me that he writes about these crazy issues.
So that's a yes to my question. You think his research and writing skills are formidable.
Yes.
During your time at Haven Landscaping, you were a landscaping technician, right?
I just worked there. I didn't have a fancy title. I just worked for Haven Landscaping.
You spread grass seed and fertilizer.
Yes, I did.
And you were only 14 at the time, right?
Yes, I was.
Now, on direct examination, you said you worked with other chemicals besides Lush, right?
Yes, I did.
But you didn't provide a list of those other chemicals, did you?
That's not in my witness statement, but I can give you an answer.
Exactly. That's not in your witness statement, is it?
No.
So the jury can't know that those other chemicals don't have other health problems, can they?
Lush fertilizer is the only product here that's relevant today. With
I understand that
chemicals it uses, it's dangerous.
I understand that that's your opinion. However, the jury can't see any of these other chemicals or their adverse health effects, right?
No.
The jury can't even see warning labels that might be on the packaging of those products, can they?
That's not in my witness statement, but I can give you an answer.
Exactly. That isn't in your witness statement either, is it?
No.
Now, you don't think you'll ever be able to recover from non-Hodgkin's lymphoma, do you?
My doctors are unsure of the treatments I might need, and non-Hodgkin lymphoma is an incurable type of cancer.
Well, speaking of your own doctor thinks you could still become well enough to pursue a career in concert piano, doesn't he?
I can't foresee anything. I can't foresee myself going to college in the future, but he thinks that I might be able to pull through, and I sure hope I do.
So that's a yes to my question. Your own doctor thinks you might still become a concert pianist?
Yes.
Now, on direct examination, you talked about how there were some guidelines at Haven Landscaping that you were supposed to follow, right?
Yes.
You were supposed to wear facial protection?
Yes.
You didn't do that, did you?
That's not true. I sometimes wore facial protection, but it sometimes got too hot and I wasn't afraid of eye irritation. There was nothing that warned me against cancer.
So that's a yes to my question. Sometimes you did not.
Yes.
And Haven Landscaping didn't have any employees that were monitoring you to ensure that you were wearing the proper protective equipment, did they?
That's not in my witness statement, but I can give you an answer.
Exactly. That's not in your witness statement either, is it?
No.
Now, you are also supposed to wear protective clothing that covers exposed skin. Am I right?
That is correct.
And once again, you didn't do that either.
That's not true. I wore protective clothing a fair amount of the time. I sometimes got too hot, though, to always wear it.
Have you ever said, pretty much everyone, including me, wore shorts and t-shirts?
Yes, but before that, I list the conditions about in the summer it being too hot to always work with all those layers and coverings.
So that's a yes to my question, you didn't wear it.
Yes.
I'd like to direct your attention to Exhibit 1, which my trial technician will be screen sharing. This is the packaging of Lush fertilizer.
Nothing is showing up for me, but if you would like, I can get the exhibit out from next to me. Oh, wait. The screen just went completely black. I can't see anything, but would you like me to get out the...
Please reference the exhibit that you have in front of you.
Okay, let me go get that.
On the bottom right-hand corner, it says, to utilize protective clothing that covers exposed skin. Did I read that correctly?
You're taking this out of context, though. If you're forgetting to say that the caution about it is that it'll cause eye irritation, not cancer, but you did read it correctly.
So that is on the packaging of the chemical?
Yes, it is.
And it also says to use a face mask or respirator, doesn't it?
This, again, it's just a user safety recommendation. It's not even listed as a warning, but yes.
Now, you knew that you were supposed to wear protective equipment.
Yes.
And you didn't wear it all the time.
I didn't wear it all the time. I wore it sometimes, but I did not wear it all the time.
Thank you, Your Honor. I have no further questions.
All right, thank you. Ms. Eisner, do you have any redirect within the scope of the cross?
Brief redirect, Your Honor.
Go ahead.
Mr. Weirs, are any products other than Lush fertilizer relevant in this case?
No. Lush fertilizer is here because of their use of chemicals like Drufo. No other product did the minimal packaging like Lush or use these dangerous chemicals. That's why Lush is here today, and that's why they are the only relevant company.
Thank you, Your Honor. No further questions at this time.
Thank you. Then the witness is excused.
Your Honor, may I conduct a brief recross?
No, you may not.
Yes, Your Honor.
I'm ready, Your Honor.
Ms. Moss, Mr. Lambert?
Yeah, can the court, can Your Honor hear me?
Yes.
I am ready.
Okay, thank you.
Ready, Your Honor.
Thank you. Team Meredith, you may call your next witness.
The plaintiff calls Dr. Casey Rogers to the stand.
I'll remind Dr. Rogers that they remain under the oath they took at the beginning of this session.
Yes, Your Honor.
Good morning. Would you please introduce yourself to the jury?
Good morning. My name is Dr. Casey Rogers.
And why are you here today?
I'm here today to discuss Strufo and its possible links to non-Hodgkin lymphoma.
Thank you. Now, before we begin, I'd like to discuss your qualifications just a little bit. What is your educational background?
I have a bachelor's in science degree in chemistry and agriculture from CSU. I also have my PhD in agriculture and entomology from UC Berkeley.
Where are you currently employed?
I currently work in the horticulture and entomology department at UC Berkeley as a professor.
And prior to working at UC Berkeley, what did you do?
I started by working as a research analyst for a large multinational chemical company.
After leaving this company, what did you do next?
I have since written many articles involving toxicology. I'm also currently working in an environmental chemistry and toxicology laboratory.
Going into more detail about that toxicology laboratory you mentioned, what exactly are you doing at this laboratory?
I'm currently working to research pesticide mode of action, information which we can use to make pesticides more environmentally friendly, as well as reduce them as hazards for humans or other non-target species.
How does this relate to Drufo?
Drufo is a pesticide that I've given special attention to over the course of my research.
Thank you. Now, aside from this toxicology lab that you worked in, what else have you done involving toxicology?
I've done a few of my own studies, as well as written articles about prolonged exposure to chemicals on the human body, especially Drufo.
Your Honor, at this time, I'd like to offer Dr. Rogers as an expert in chemistry, agriculture, and toxicology with a specialization in the effects of prolonged chemical exposure on humans and the effects of prolonged exposure to Drufo under Rule 702.
Is there an objection to the acceptance of Dr. Rogers as an expert in the fields of chemistry, agriculture, and toxicology?
Your Honor, we have no objection to those specific fields. However, we do have an objection to the specific emphasis on the human body. Dr. Rogers has laid no foundation to having proper education or experience in researching the effects toxins can have on the body or making any conclusions based off of this research.
Mr. Miley?
Yes, Your Honor, Dr. Rogers has shown throughout her various experience with toxicology and the numerous articles she's written about how it relates to the human body that she does in fact have the necessary knowledge to testify under an expert opinion in that field, seeing as she does in fact have a lot of experience in said field.
Ms. Burton?
Your Honor, Dr. Rogers has only mentioned specifically 2 studies about Drufo and just their general being, no specific research on how this chemical could affect the body. In addition, she has only laid small foundation to effects of Drufo on the body, not toxicology as a whole.
I'm sorry, I don't understand the distinction you're trying to make between the effect of Drufo and toxicology as a whole.
Yes, Your Honor. Dr. Rogers has only testified to doing a small amount of research on how Drufo could possibly affect the body. Therefore, as opposing counsel is trying to admit her with an emphasis on toxicology and how it can affect the body as a whole, as Dr. Rogers has only researched one specific chemical, she does not have the proper foundation to have a general knowledge of toxicology and how it can affect the body.
Mr. Miley?
Yes, Your Honor, Dr. Rogers has not studied one chemical exclusively. She has worked with numerous chemicals throughout her experience in involving toxicology laboratory she mentioned. In addition, under Rule 702, a person needs to have proper knowledge, skill, or experience to testify as an expert. And Dr. Rogers has, in fact, all 3 of those things, as she has worked with the human body and how chemicals affect it on numerous occasions.
Okay, I think that the objection that is being presented against Dr. Rogers goes to an interface between the general work she has done and the specific work she is going to testify to, apparently, about Drufo. As a matter of preliminary matter, I can't rule on that distinction without a specific context of facts. So I'm going to overrule the objection, accept Dr. Rogers as an expert in the fields of chemistry, agriculture, and toxicology, and allow specific objections to specific questions that could be hashed out in that context. So overruled, and go forward.
Yes, Your Honor.
Dr. Rogers, why are you here today?
I'm here today to give my expert opinion regarding Drufo.
And what is that opinion?
In my expert opinion, Drufo causes non-Hodgkin lymphoma.
Objection, Your Honor. This is improper expert testimony pursuant to Rule 701C, as Dr. Rogers was only qualified as an expert in chemistry, agriculture, and toxicology, and has no medical background. She cannot specifically testify to conclusions of how chemicals could be cause different cancers.
Mr. Miley?
Yes, Your Honor. Dr. Rogers was also entered as an expert in the effects of prolonged chemical exposure on humans, one of these effects being non-Hodgkin lymphoma. Dr. Rogers is not testifying to a specific medical diagnosis, merely what a chemical does to the human body, which is under her area of expertise.
Your Honor.
Ms. Burton?
Your Honor, if I'm not mistaken, I only heard Dr. Rogers being qualified as an expert in chemistry, agriculture, and toxicology with no qualification on the emphasis of effects this could have on the body. Therefore, she does not have the proper expertise in today's case to make these conclusions pursuant to Rule 701C, which co-enacts with 702.
Well, the doctor was accepted as an expert in the fields of chemistry and toxicity. If the chemical reaction in which she is an expert causes a toxic reaction with which she is an expert, then I think she is qualified to render that opinion. As she's qualified to render that opinion, and you, of course, as in cross-examination, have the opportunity to undermine or suggest that the conclusion she has reached is not valid. So the objection is overruled.
Yes, Your Honor.
I'll re-ask the question, Dr. Rogers. What is your expert opinion?
In my expert opinion, Drufo causes non-Hodgkin lymphoma.
Thank you. Now, I'd like to move on to discuss a little bit more about Drufo. Doctor, if you could please explain to the jury, what is Drufo?
Drufo is a chemical that was developed and patented by Lush. It's used in most of their fertilizer products as sort of a bonding agent or preservative for these fertilizers.
Why did you decide to investigate Drufo specifically?
I felt it had been rushed to market and I had concerns over its safety. It seemed to me that enough studies hadn't been done to ensure that Drufo would be safe for consumers.
How did you investigate your concerns?
I decided to conduct my own study into the safety of Drufo.
Let's break down this study. How did you begin this study?
I began by creating 3 different groups with a variety of levels of exposure to Drufo.
What was the first group?
The first group I used was a control group. This was a group of people with no exposure to Drufo. I use a group like this to make sure that I'm not accidentally linking health effects that aren't being caused by Drufo to Drufo.
What was your second group?
My second group was a group of people with very limited or occasional exposure to Drufo.
What was your third group?
The third group of people was a group with high, prolonged levels of exposure to Drufo. I picked people that included farmers and gardeners who used Drufo on a regular, almost daily basis to tend to their crops.
Thank you. Now, after selecting your 3 groups, what did you do next?
I monitored these groups over a period of a few years, and I compared the two groups with exposure to the control group to see if any prolonged health effects had arisen.
What did you find?
I found specifically higher instances of cancers, including non-Hodgkin lymphoma, in the groups that used Drufo.
What did this mean?
I found that the group with high prolonged levels of exposure was 10 times more likely to develop non-Hodgkin lymphoma than the group with no exposure. And that group was 5 times more likely than the group with occasional exposure to develop non-Hodgkin lymphoma because of Drufo.
Over the course of your study, did you investigate anything else?
Yes, I also looked into ways that the effects of Drufo could be mitigated or prevented.
So, Dr. Rogers, what is the best way to prevent exposure to Drufo?
While you could wear long pants, long sleeves, or a mask, the best thing to do, honestly, is to discontinue the use of Drufo altogether.
Thank you. Now, I'd like to move on to discuss a little bit more about non-Hodgkin lymphoma. Doctor, what is non-Hodgkin lymphoma?
Non-Hodgkin lymphoma is a type of cancer that affects your immune system.
How can it develop?
Unlike some cancers, non-Hodgkin lymphoma isn't genetic, so it has to come from some environmental factor, which in this case includes Drufo.
Thank you. Now, I'd like to move on to discuss the plaintiff today, Dakota Weirs. How are you familiar with Mr. Weirs' case today?
As a part of this case, I reviewed Mr. Weirs' medical files as well as his employment records.
What did you find by reviewing these files?
From my review, it seems that Mr. Weirs had a similar level of exposure to Drufo as the third group in my study, that being a high, prolonged exposure to Drufo.
What did this mean?
This means that based on his exposure, Mr. Weirs was 10 times more likely to develop non-Hodgkin lymphoma because of his exposure to Drufo than if he hadn't been exposed.
Doctor, in your expert opinion, what conclusions can be drawn about today's case?
In my expert opinion, Drufo causes non-Hodgkin lymphoma, and there's a high degree of probability that it caused the Mr. Weirs non-Hodgkin lymphoma.
Thank you, Your Honor. No further questions at this time.
Thank you. Ms. Burton, you have cross-examination.
Yes, Your Honor. Now, Dr. Rogers, as a toxicologist, you've researched many different chemicals, correct?
That is true, yes.
And when making your conclusions about these chemicals, you rely on scientific data. Do I have that right?
Yes.
Now, specifically in today's case, you claim Drufo was rushed into the market without sufficient safety studies. Yes?
Yes, that is how I feel, yes.
However, before making this claim, you never reviewed any of Lush Fertilizer's in-house studies. Yes?
That is not in my witness statement, but I can give you an answer if you'd like.
Exactly, Dr. Rogers. That's my point. Nowhere in your affidavit do you ever mention what you based these conclusions off of, correct?
I don't mention it, no.
You're aware you had to provide all relevant information in your affidavit?
I am, yes.
So nowhere do you ever mention any specific data for this claim, correct?
I do mention that I felt that there weren't enough studies to properly justify the safety of Drufo, but I don't mention any specific data, no.
Now, going to the product that you claim caused Ms. Weir's cancer, you reviewed Dakota's medical records before making this conclusion, correct?
I did, yes, as well as his employment records.
And from her employment records, you knew that she was exposed to countless chemicals at Havens Landscaping, correct?
It appeared so, but I also saw that they worked with Drufo regularly for 4 years, giving them a high prolonged level of exposure to it.
However, going to the other chemicals he worked with, you never received a list of these chemicals, correct?
That is not in my witness statement.
Yeah, Dr. Rogers, again, that's exactly my point. Nowhere in your witness statement do you ever mention the other chemicals Dakota worked with, correct?
My research involves Drufo. So based on the levels of exposure to Drufo I saw in his employment and medical records, I could make the conclusions I made regarding my research involving Drufo.
So Dr. Rogers, you never looked into the other chemicals Dakota worked with, correct?
My research is into Drufo, so no, I did not.
And those other chemicals are not here today in trial, correct?
It doesn't appear so, no.
So hypothetically, any one of these other chemicals could be directly linked to non-Hodgkin's lymphoma, and the jury would never know, correct?
As Drufo, based on my study, is linked to non-Hodgkin lymphoma, that is what likely, in my expert opinion, caused Mr. Weir's cancer. As to the other chemicals, I cannot say.
Now, Dr. Rogers, you just mentioned your own study on Drufo. You did a study on the effectiveness of wearing protective clothing when working with the product, correct?
I did, yes.
And this study came out inconclusive, yes?
We didn't have proper time to finish this study, but yes, it was inconclusive.
However, you still recommended that users wear protective clothing when working with the product, correct?
Yes, that is a potential precaution, yes.
And you said that most importantly, they wear a face mask, like an N95. Do I have that right?
Yes, that is most important, though it cannot fully prevent the risks that Drufo poses.
Now, I want to talk a little bit about Lush fertilizer and its safety recommendations. I'll have my trial technician pull up Exhibit 1 if we're not still having technical difficulties. Dr. Rogers, do you see Exhibit 1 in front of you?
I do not, but I can pull out my paper copy if that's what works.
If that's possible, yes, I'll also have it in front of me. Seems like we have it. Now, Dr. Rogers, I'll have my trial technician start at the top with the hazard section. Now, right here, it says keep out of reach of children. Dakota was only 14 when he started working at Havens Landscaping, correct?
It seems that way, yes.
And he continued working there while he was 15, 16, and stopped somewhere around 17. Do I have that right?
I suppose so. I haven't talked with Dakota, so I wouldn't know for sure.
However, you reviewed his employment records, correct?
I did, yes.
Now, moving a little down the packaging, I'll also have my trial technician highlight the user safety recommendations. Now, Dr. Rogers, first it says to utilize protective clothing that covers exposed skin when working with the product. But Dakota never wore protective clothing, correct?
It appears that way, though even if he had, it couldn't have fully prevented the risks that he was exposed to by using Drufo.
However, you still recommended that it's reasonable to wear protective clothing, correct?
It's reasonable, yes, but it still can't fully prevent the risks.
And going further down the packaging, it says to use an N95 face mask when working with Drufo. But Dakota didn't do that either, correct?
Again, it appears he did not, though even if he did, the risks would not have been fully mitigated.
And just to be clear, you said wearing an N95 face mask was most important. Do I have that right?
Among the recommendations I made, yes, it's most important. But again, it cannot make someone completely safe from Drufo.
So to clarify for the jury, Dakota didn't follow the safety recommendations on Lush Fertilizer's packaging, correct?
It appears he did not, no.
Thank you, Your Honor. Exhibit 1 can be taken down, and I have no further questions at this time.
All right, thank you. Mr. Miley, do you have any redirect?
Yes, Your Honor.
Go ahead.
Dr. Rogers, did you need to review Lush's other studies conducted by Lush to build a foundation for your conclusions?
No, I did not. Drufo was a new chemical at the time it was introduced to the market. And so the studies that had been done on it, there didn't seem to be enough of them to prove that it was safe for the users.
And Dr. Rogers, what is the best way to prevent exposure to Drufo?
It's quite honestly to not use Drufo altogether. Even when using personal protective equipment, you can't fully eliminate the risks it poses.
Thank you, Your Honor. I have no further questions at this time.
All right, thank you. Then the witness is excused.
I'm ready, Your Honor.
I'm ready, Your Honor.
I'm ready, Your Honor.
All right, thank you. Floyd, if you may call your next witness.
The plaintiff calls Carson Durst to the stand.
I'll remind the witness that the oath taken at the beginning of this proceeding is still in effect. Go ahead.
Good morning. Please state your name for the court.
Hello, my name is Carson Durst.
What is your profession, Ms. Durst?
I am the lead product developer and the head of research and development at Terrace Greenery, a fertilizer company.
What education have you received, Ms. Durst?
I have a bachelor's of science in chemical engineering from Arizona State University.
I'd like to begin by discussing your work experience. Have you worked anywhere besides Terrace Greenery?
Yes, after college in 2003, I received an internship from Lush Fertilizer Incorporated.
How did you get this internship?
Well, after college, when I was looking for a job, Mr. Doncourt, the CEO of Lush, put in a good word for me, and I got the internship because of my qualifications.
How did your career at Lush progress?
I worked my way through the ranks, and later in 2003, I made my way to product development engineer.
Why did you leave this job?
Well, unfortunately, my employment at Lush was terminated in 2006.
Why was your employment terminated?
I received some negative performance reviews.
Who wrote these performance reviews?
My supervisor, as well as the Jufo product manager, Jerry Langley.
And when did you begin receiving these performance reviews?
I'm not sure of the exact time, but it wasn't long after Lush's study about Jufo that I participated in.
We'll come back and talk more about this study later on, but right now I want to talk more about these performance reviews. Did you attempt to discuss them with your supervisor?
No, in hindsight, I should have, but I did try discussing it with Blake or Mr. Doncourt, and it didn't go well.
What do you mean it didn't go well?
When I tried discussing the performance reviews with him, he refused to intervene and he wouldn't listen to my concerns. I felt really betrayed and upset.
Now, I'd like to move on and discuss your employment at Lush. Now, what did you do at your job at Lush?
I worked on the research and development team, and when I started my internship, I was part of a study to test the safety of Jufo, Lush's flagship product and a bonding agent in many of Lush's fertilizers.
When did this study occur?
It started in early 2003 and it ended sometime in the summer.
Now, what was your role in this study?
I researched on the chemical compounds in it, C3NO9P or nitrogen phosphorus carbonate.
What is important about nitrogen phosphorus carbonate?
Well, it's a bonding agent, so it takes the active ingredients in the fertilizers and it bonds it to the plant. And this bonding agent is what makes Jufo such a useful tool.
Objection, Your Honor, may I be heard?
Yes, you may.
This is an improper expert opinion pursuant to Rule 702, given that Carson Durst has not been admitted as an expert in today's case and therefore lacks the education, experience, and training to testify about the specific components of C3NO9P.
Ms. Abbott?
Yes, Your Honor, Ms. Durst has testified that she has completed extensive research at her job regarding this specific chemical, in addition to proving that she has the education necessary to understand this research. Ms. Durst is not testifying to an expert opinion. She is simply testifying as to her own personal knowledge based off of her research of this chemical.
Mr. Hernandez?
Your Honor, seeing as this personal knowledge requires expert testimony to explain it to the jury, it is improper pursuant to Rule 70C that coincides with Rule 702.
Ms. Abbott?
Your Honor, Ms. Durst's knowledge of this chemical does not require expert testimony. Her knowledge of how this basic chemical works was gained through her research and is a simple overview for the clarification to the jury of how this works based on her own personal knowledge and does not require expert testimony.
Well, I think that the foundation has been laid that the witness worked with Jufo and participated in the preparation and study of Jufo in the course of her employment. And while she has not been accepted as an expert, she has the experience to testify about matters that are rationally based on her perception in the course of her employment. And this will be helpful for the jury to clearly understand the witness's testimony and determining a fact that is at issue. Therefore, the objection is overruled.
Yes, Your Honor.
Yes, Your Honor. Ms. Durst, please continue your answer.
So as I was saying, nitrogen phosphorus carbonate is a bonding agent, which is what makes it so useful.
Now, in your research about this chemical, what did you learn?
I looked into nitrogen phosphorus carbonate and other studies being done about it, and I found one study in particular that was useful to the safety of Drufo, and it recommended that Drufo's possible carcinogenic effects on humans be researched.
And what did you do with this research?
I wrote it down in my lab notebook.
What happened to your lab notebook?
It's standard procedure for my supervisor to compile everyone's notebooks into a report and send that report up to management.
And what happened after that?
I received an email about the upcoming study.
Who sent this email?
My supervisor, Ms. Langley.
Ms. Durst, could you please refer to the copy of Exhibit 4 that you should have in front of you?
Yes.
Now, do you recognize Exhibit 4?
Yes, I do.
What is Exhibit 4?
It's a copy of the email I received from Ms. Langley about the upcoming study.
How did you come across this copy?
I saved a printout of the copy before after I received it.
Now, is this a complete and accurate copy of this printout you saved?
Yes, it is.
Your Honor, I move to enter Exhibit 4 into evidence.
Is there an objection to the admission of Exhibit 4?
Yes, Your Honor. I have 5 individual objections to make to this exhibit. Would you like to take those one at a time or get them all out there at once?
Well, why don't we take them one at a time?
Yes, Your Honor. While we acknowledge the witness testified that this exhibit is authentic and from an employee of Lush Fertilizer that should meet the requirements of 901 and 801D2, it is not that simple. As an offer of proof, Blake Doncourt, a supposed recipient of that email, will testify to never having received that. Further, both the plaintiff and defense of today's trial were able to locate the company's servers and did not find this email anywhere. And as such, a question of this exhibit's authenticity has been raised pursuant to Rule 901, as it is a possibility that Carson Durst may have fabricated this email for court today.
May I respond, Your Honor?
Yes, you may.
Your Honor, Ms. Durst is not attempting to enter, or excuse me, we are not attempting to enter the original copy of this email into evidence. We are attempting to enter a printout or a duplicate of this email that Ms. Durst has saved. As such, under Rule 1004, this email is admissible because a duplicate is admissible instead of an original copy if the party that controls the original copy, which in this case is Lush Fertilizer Incorporated, is the party that this information is being offered against. As Lush Fertilizer Incorporated is the defendant in today's trial and the party opponent of the plaintiff, this information is being offered against them, and this email is therefore admissible.
Isn't there a stipulation that the exhibits are authentic?
No, Your Honor. It is simply stipulated that the signatures on the end of the affidavits are authentic.
I believe that is correct, Your Honor.
All right. Well,
Your Honor, may I respond?
no, I've heard enough, because what you are doing is attempting to prevent the admission of an exhibit by impeaching it. You're free to impeach it on cross-examination. However, there is a sufficient foundation that has been laid by this witness that she received the email during the course of her employment and retained a copy of it. While you may be able to undermine the credibility of it and raise implications that it was manufactured by someone, that is a matter of cross-examination. So the objection is overruled. What's your next objection?
Your Honor, my next objection would add a simple nuance to the authenticity objection, given that.
Well, I don't want to hear more nuances. If these are just variations on a theme, I don't need to hear 5 objections.
Well, with that, Your Honor, I would add that this is hearsay pursuant to Rule 801, given that it is an out-of-court statement that is being used to prove the truth of the matter asserted. The truth of the matter asserted being that this email was in fact sent to the recipients mentioned, including Blake Doncourt, who has no knowledge of having received it.
May I respond, Your Honor?
Yes, you may. Sorry.
No, my apologies. I have two separate responses to this. First of all, pursuant to Rule 801D2, this email is a statement of a party opponent and therefore not hearsay. As the party opponent to the plaintiff in this case today is Lush Fertilizer Incorporated, and the creator and sender of this email, Ms. Jerry Langley, was the Drufo product manager and an employee of Lush Fertilizer Incorporated. At this time this email was sent, this email is in fact a statement of a party opponent and therefore not hearsay. Furthermore, this email is not being offered for the truth of the matter asserted. It is being offered for the effect on the listener, in this case, Lush Fertilizer Incorporated, to show the knowledge about this chemical that they had in their possession when they made the decision not to bake their fertilizer, which is not the truth of the matter asserted as to whether or not this chemical does in fact cause cancer.
Well, I would only dispute the last part of it because I think you are putting it in to prove the proof of what it contains. Otherwise, it wouldn't make that much sense. However, the rest of your response is well taken because this is a statement of a party, a purported statement of a party against its own interest, and therefore it's not a hearsay matter. And the objection, that part of the objection is overruled.
With that, Your Honor, I have no further objections.
All right, then Exhibit 4 is admitted.
Your Honor, permission for co-counsel to publish to the jury via screen sharing?
Yes.
Now, Ms. Durst, could you please read the first sentence of the second paragraph of this email out loud to the jury?
Following our lab's June Drufo study, concerns have arisen regarding generalized findings of potential carcinogenic qualities identified in samples produced during a period early in the year.
Could you please explain what this means?
Yes, it's referencing the findings of me and other scientists who worked on the original test.
Now, Ms. Durst, who received this email?
People like me who are going to be working on the September study.
Did anyone else receive the email?
Yes, higher up management like Alex Monroe and Blake Doncourt received this email as well, and you can see their names at the top of the page there.
Now, Ms. Durst, was this the only communication regarding this study that you received?
No, we also learned more in staff meetings.
What happened in these staff meetings?
Well, Lush officials explained the agenda and their specific expectations for the study.
What were those specific expectations?
For us to reach the conclusion that they wanted, that Drufo was not carcinogenic.
What happened that made you think they wanted this conclusion?
I was pressured to present my data in a way that would support this conclusion, not the way I would present it based on the science. It was clear to me that management was more concerned with rushing the product to market than the results of the test.
Objection, Your Honor, may I be heard?
That's why you're standing up. Please, what's your objection?
Your Honor, pursuant to Rule 701, this is speculation, given that Ms. Durst is making an opinion that is not rationally based on her perceptions and observations, given that they cannot see into the mindset of her supervisors, into whether or not they wanted a certain outcome from their studies. And as such, there is a lack of foundation to this pursuant to Rule 602, given that Ms. Durst has not testified to having a method in which she can look into the brains and thinking process of her supervisors.
Ms. Abbott?
Your Honor, Ms. Durst is simply testifying to her personal interpretation of the actions she witnessed these people, these employees of Lush Fertilizer, take. She is testifying an opinion that she believes based on the information she saw and her own personal knowledge. She's not speculating.
Well, I think the problem with the question is that there is no foundation that supports her inference that there was a bad intent on the part of her employers. And there's no information that indicates how she was pressured. So if you want to lay that foundation, perhaps there's a reason for her to testify to what she is opining about the actions of her employer. So to that extent, the objection is sustained.
Yes, Your Honor.
Yes, Your Honor.
Ms. Durst, what happened after you had this meeting?
Well, everyone who worked on the second study explained their findings in a meeting with my supervisor, Ms. Langley. And Another scientist working on the study found concern Drufo was a carcinogen, and specifically that it was linked to non-Hodgkin lymphoma.
And what was the reaction of the Drufo employees to this statement?
When they didn't receive the results they wanted, Mr. Monroe, a higher up manager, told us we couldn't talk about the findings.
Now, what happened after this meeting?
I received a report from management.
And do you agree with what you read in this report?
No, not at all. The entire thing was incredibly misleading. I'm sure some data was left at the report.
Why do you think that?
Well, another scientist who worked on the study and said their concerns wasn't addressed at all in the report.
Do you disagree with anything else in the report?
Yes, I also disagree with the report's recommendation that Drufo be baked.
What is baking?
From my understanding, it's taking the product and putting it into an oven, and this eliminates any possible carcinogenic properties of the product.
Why do you disagree with the report's recommendation that Drufo be baked?
Well, from my understanding and everyone else's research, baking was the only way to mitigate Drufo's possible carcinogenic effects, and suggesting doing something that stops your product from giving people cancer does not seem strong enough to me.
Thank you. No further questions.
Thank you. Mr. Hernandez, you have cross-examination.
Yes, Your Honor. Now, on direct examination, you mentioned that the second study was incredibly misleading, correct?
I said that the report was incredibly misleading. Yes.
However, you didn't have access to all the research that was conducted, correct?
Well, I had access to most of the data. I didn't have access to all of it, no.
Exactly. Now, we will readdress that second study in a moment, but for the time being, you were fired from Lush Fertilizer in 2006, right?
It was unwarranted, but yes, I was.
You haven't worked at the company since then?
I worked from 2003 till 2006, yes.
You have been working at Terrace Greenery for over 15 years now, right?
Yes, that is correct.
You're the lead product developer at Terrace Greenery?
Yes.
And Terrace Greenery is a direct competitor of Lush Fertilizer, isn't it?
Fertilizer companies, there's millions of them, or thousands of them, sorry. So there's many other competitors to Lush Fertilizer.
But that's a yes to my question. Terrace Greenery is a direct competitor of Lush Fertilizer.
Both are large fertilizer companies, so yes, they are competitors.
Now, when you joined Lush Fertilizer as an intern, it was in June of 2003, right?
Around then, yes.
And you were never promoted to anything beyond a product development engineer, were you?
I was promoted to a full-time product development engineer, so no, I was not promoted to anything else.
And you never conducted any studies of your own?
I worked on the research that they gave me to work on.
You have never run an entire toxicology research and development lab like Dr. Williams, have you?
I researched chemical compounds in Drufo, but no, I did not run a whole toxicology department.
So, misters, when you were brought on by Lush Fertilizer, the company was in the middle of conducting the research and safety of Drufo, right?
Yes, that is correct.
There were engineers and scientists involved in that research and testing?
Yes.
And the company had procedures in place to monitor their ongoing studies, right?
Yes, we had meetings and other things. Yes.
The company would release results of their studies to the team working on them. Isn't that right?
We received reports written by management after collecting everyone's notebooks and information in our notebooks.
Now, on direct examination, you mentioned the second study conducted by Lush Fertilizer and the concerns that were risen from that study. However, you received a copy of the study report, correct?
Written by management, yes.
And the study report had a statistical analysis about the effects of Drufo, didn't it?
I think so, yes.
we can agree there are certain legal requirements that Drufo had to meet in order to be sold, right?
Apparently,
And the study determined that Drufo was within those legal requirements, right?
I was not, I was a researcher. I did not know of the legal requirements that were needed. That's what management dealt with.
Mr. Have you ever said that the study report stated, on average, our statistics and our distribution is below what is required by law?
Yes, I did believe it. I do believe I said that.
Now, the study went as far as to say that baking Drufo would not be necessary because it already met those legal requirements, right?
That's what management wrote, but again, I don't agree with that.
Well, the study also recommended that further research be conducted. Isn't that right?
Yes, because we weren't sure if there were carcinogenic properties, and it's important to research to find if any carcinogenic properties are present.
However, you couldn't do your job well enough to be involved in any of those future studies. Isn't that right?
I did my job perfectly fine. It was other people who wrote my performance reviews. I think I did my job well. I wrote my research in my lab notebook, and I did all that I was supposed to do.
Mr. There were mounting complaints from the staff, right?
Unwarranted, but yes, there were.
There were mounting complaints from your coworkers. Isn't that right?
Unwarranted, but yes.
So after some time, you started looking for work outside of Lush Fertilizer, right?
Lush Fertilizer was no longer a good fit for me, so I wanted to look at other companies that were in the same field.
And you were hired by a competitor of Lush Fertilizer.
I was hired by another fertilizer company because of my qualifications.
But despite being hired by a competitor of Lush Fertilizer, you kept on working for them, didn't you?
Can you repeat the question, please?
Mr. Despite being hired by a competitor of Lush Fertilizer, you kept on working for them, didn't you?
For Lush Fertilizer?
Yes, Mr.
I worked for them for a little bit longer, but I left and I worked for Terrace Greenery.
You worked with Lush Fertilizer for the rest of 2005.
Yes.
You worked with Lush Fertilizer for the majority of 2006.
For some of it.
Despite being hired by a competitor of Lush Fertilizer, you kept on working for them until you were fired in December of 2006. Isn't that right?
I believe so, yes.
And in your first few years at the company, you worked on a product that directly competes with Lush Fertilizer's equivalent, right?
I was working for Terrace Greenery after Lush Fertilizer, but I wasn't working on the study that has anything to do with Lush Fertilizer.
Mr. That wasn't my question. In your first few years at Terrace Greenery, you worked on a product that directly competes with Lush Fertilizer's equivalent, right?
Objection, Your Honor. Relevance.
Mr. Hernandez, you have a response?
Your Honor, seeing as Mr. no longer works at Lush Fertilizer and is now at a competitor, it is extremely relevant to mention the fact that Mr. may have a financial bias in today's case that can be affecting their testimony.
Ms. Abbott?
Your Honor.
Your Honor, nothing has been established that Ms. Durst has any type of financial bias in this case. Opposing counsel is simply asking her about her work at this fertilizer company regarding other products that has no bearing on the issue at hand today of whether or not one specific product from another company causes cancer.
Your Honor, if I may respond.
Briefly, yes.
I am currently laying the foundation to testify about whether or not Mr. has a financial bias in today's case.
Well, obviously you are free to pursue that line of questioning and to establish that financial bias. I think that the objection is not well taken because the fact that the witness is working for a competitor and working on a competitor's product that directly competes with the defendant's product is an indication in itself that there may be some financial bias or other kind of bias, competitive bias with this witness as opposed to her current employer. Therefore, the objection is overruled. Go ahead, Mr. Hernandez.
Yes, Your Honor. So, Ms. Durst, yes or no? In your first few years at Terrace Greenery, you worked on a product that directly competes with Lush Fertilizer's equivalent.
In my first 4 years, I did start working on different products, yes.
You specifically worked on a product that competes with Lush Fertilizer, right?
Yes.
And if Lush Fertilizer is found liable today, your company will likely overtake Lush Fertilizer in the market. Isn't that right?
I came here to put what I think about Drufo's possible carcinogenic effects. If Terrace Greenery's product overtakes Lush, it won't be because of financial bias. It would be because our product is better.
So that's a yes to my question. If Lush Fertilizer is found liable today, your company will likely overtake them in the market.
It's not yet, so I'm not sure. It could possibly.
And Ms. Durst, you have never disclosed how much Terrace Greenery is paying you to testify against them today, have you?
I don't see how that's relevant, no.
Thank you, Your Honor. No further questions.
All right, thank you. Ms. Abbott, do you have any redirect?
Yes, Your Honor, a brief redirect. Ms. Durst, does your financial bias affect at all your testimony here today?
No, not at all. I came here to provide the facts of my research about Drufo, not about no financial biases here.
And after you were hired at Terrace Greenery, were you working for Lush and directly competing with Terrace Greenery?
No, I applied to Terrace Greenery, and after I got fired, I started working after I got fired from Lush, I started working at Terrace Greenery.
Thank you. No further questions.
All right, thank you. The witness is excused.
I'm ready, Your Honor.
I'm ready, Your Honor.
I'm ready, Your Honor.
All right, thank you. Plaintiff, do you have any other witnesses?
No, Your Honor, the plaintiff rests.
Thank you. Defense, you may put on your first witness.
Yes, Your Honor. The defense calls Dr. Devin Williams to the stand.
Remind the witness that the oath taken at the beginning of this proceeding remains in effect. Go ahead.
Good morning. Could you please introduce yourself to the jury?
Good morning. My name is Dr. Devin Williams. I'm the chair of the Ethics Committee, and I lead the Toxicology Research and Development Labs at Lush Fertilizer Incorporated.
And could you explain to the jury exactly what toxicology is?
Of course. Toxicology is the study of how environmental factors impact the human body and the environment. I research and evaluate test results to determine whether a substance could cause harm, and if it does, how to mitigate that harm.
Mr. Hernandez, I'm going to intercede for a minute here. Could you move the camera a little bit, I guess, to your right?
Yes, Your Honor.
So that the witnesses in the picture.
Yes, Your Honor. I actually failed to turn on our witness camera that we have.
Okay, thank you.
Can you see Dr. Williams all right?
I think she has to speak to come on my screen. Dr. Williams, would you say hello or something?
Hello, Your Honor.
That did not.
Your Honor, seeing as we solely have one microphone available in our courtroom today, the Zoom setting will have to be changed from speaker view to gallery view in order to.
I see that. I've done that. Thank you. Go ahead.
Yes, Your Honor.
Apologize for the interruption.
No apologies necessary. Now, Dr. Williams, did you receive any education in the field of toxicology?
Of course, I earned my master's in forensic toxicology, my PhD in pharmacology and toxicology, both from Colorado State University, and I also completed a specialized post-PhD program in pharmacotoxicology at the University of Utah.
Now, I'd like you to take a look at Exhibit 9 there in front of you. Let us know when you have it.
I have it here.
And could you explain exactly what this exhibit is?
This is my curriculum vitae. It's really just a fancy word for resume. It includes all of my certifications, work experience, education, and publications.
And did you create your own curriculum vitae?
Yes, as is standard for experts in my field.
Is it fair and accurate to the best of your knowledge?
Yes, it is.
Is it kept and updated regularly?
Yes.
Your Honor, at this time, I move to admit Exhibit 9 into evidence.
Mr. Miley, is there any objection to the admission of Exhibit 9?
No objection, Your Honor.
Then Exhibit 9 is admitted.
Yes, Your Honor. I ask that my trial technician be allowed to publish to the jury.
Granted.
Now, Dr. Williams, aside from what you've already testified to, what can Exhibit 9 show us?
Just to give you the highlights, you can see the 4 courses I teach in toxicology at the University of New Mexico, my several certifications in both clinical and forensic toxicology, as well as my research, some of which is in the process of being properly peer-reviewed and replicated.
Thank you. My trial technician can take that down now. And Your Honor, at this time, I ask that the court recognize Dr. Devin Williams as an expert in the field of toxicology.
Mr. Miley, is there any objection to the acceptance of the witness as an expert in the field of toxicology?
I have a voir dire, Your Honor.
Go ahead.
Hello there, Dr. Williams. It is true you have no background in oncology, yes?
No, although I have researched oncology as it relates to toxicology.
You also have no medical background at all.
Toxicology is a medical field, and I did work for a good while at the medical examiner's office.
However, you don't have any experience relating medicine to humans directly.
That is what pharmacology is, counsel, the study of how specifically pharmacological drugs affect the human body. So yes, I do.
I'd like to move on to discuss Dakota Weirs. You have not conducted a medical examination on Mr. Weirs, yes?
No, I did not.
You have not met with Mr. Weirs.
No, although I am aware of his circumstances.
And you haven't reviewed any of his files.
I did not review his medical or work files, no.
Your Honor, at this time, while I do not object to Dr. Williams being entered as an expert in toxicology, I would like to limit her testimony to not include any medical opinions or opinions regarding Dakota Weirs, seeing as she does not have the necessary skill, knowledge, or training under Rule 702.
Well, I'm going to accept the doctor as an expert in the field of toxicology. I'm not prepared at this time to rule on any specific question, and you'll have to raise those objections if you deem them appropriate as they come up.
Yes, Your Honor.
Mr. Hernandez, go ahead.
Yes, Your Honor. Dr. Williams, earlier you mentioned you work as the lead of the toxicology research and development labs at Lush Fertilizer. Could you explain what your job there entails?
Sure. I oversee all work on the environmental impacts and safety of Lush Fertilizer products, specifically Drufo.
What is Drufo?
Drufo is a patented binding agent. What it does is it glues the fertilizer components both to themselves and to the plants that it's sprayed on, meaning that less fertilizer has to be used in the long run, which is beneficial for both the environment and human health.
And did Lush Fertilizer ever test this product?
Of course, we did extensive testing on both the safety and environmental impacts and made sure to do follow-up testing if any concerns arose.
What kind of process did Lush Fertilizer use to test the product?
We use what's called correlational studies, which is when we take 2 or more very similar groups and look at the existence of certain factors.
And how do you know that the differences between these groups aren't caused by something else entirely?
So when we're looking for the what is correlated with which factor, such as the use of Drufo possibly being correlated with cancer, we have to make sure that we eliminate or at least vastly reduce what's called confounding variables. These are other variables that differ between the groups, such as diet, exercise, sun exposure, really anything that could affect someone's risk of, in this case, being diagnosed with cancer.
Can you effectively control for every possible variable?
No, there are some variables which are simply too unlikely to consider, such as the blatant misuse of a product or the use of it by a child.
Now, Dr. Williams, have you been made aware of Dr. Rogers' study?
I have, and as a fellow researcher, it's extremely concerning.
How so?
Dr. Rogers' study is inherently flawed because of the study groups that she used. She compared farm laborers to hobby gardeners to run-of-the-mill people. Going back to the confounding variables that I mentioned earlier, there are simply too many to actually make any sort of valid conclusion from the study.
Now, aside from these differing study groups, did you have any other concerns with Dr. Rogers' study?
Yes, the study itself was never peer-reviewed or replicated. Specifically, replication is the process when another independent scientist reviews the data and reconducts the study to make sure that it's accurate. Otherwise, the data could very well be a one-time fluke or the result of bias.
So, in your expert opinion, was Dr. Rogers' study misguided?
Yes, from the number of confounding variables that were present, there's no way any valid conclusion could have been drawn.
In your expert opinion, was Dr. Rogers' study misinformed?
Absolutely. Dr. Rogers tried to conclude that Drufo causes cancer, which even if the study was conducted correctly, there's no way that she could have concluded causation. It's simply not possible. The truth is that Drufo has not been linked in any way to a higher risk of being diagnosed with any form of cancer.
And throughout the trial, we've heard of Ms. Weirs, the plaintiff's, constant misuse of other fertilizers. How does this affect your conclusions?
Any one of those fertilizers could have contributed to Mr. Weirs's unfortunate diagnosis. However, from the research that I know, from the research that exists, it is not possible that Drufo led to his cancer.
Thank you, Your Honor. I have no further questions.
Thank you, Mr. Miley. You have cross-examination.
Yes, Your Honor. Hello again, Dr. Williams. I'd like to first begin by discussing Lush's reaction to Drufo being banned in the EU. Drufo was banned in the EU, yes?
For nitrogen content, yes.
It was banned roughly 18 years ago.
That's correct.
And in all that time, Lush has not fought the ban.
We're actually working on research to overturn the ban as we speak.
However, up until this point, Lush has not done anything to fight the ban.
As I said, we are conducting research, so that has been ongoing for some time.
But Lush has not actually fought this ban.
Objection, Your Honor, asked and answered.
Mr. Miley?
Your Honor, I am trying to clarify, seeing as the witness has not actually answered the question as to whether or not Lush has or has not fought the ban, and I'm trying to receive clarity so the jury can understand more clearly.
I think that the difference between the answers and the questions adequately supports Mr. Miley filing up, and therefore the objection is overruled.
Yes, Your Honor.
I'll re-ask my question. In 18 years, Lush has not fought the ban in the EU, correct?
We have not overturned it yet, no.
And in the beginning, one of the resources you were lacking was money, yes?
Yes, it was impossible to find the funding to do the research.
Now, if it were determined today that Drufo does in fact cause cancer, that would create a whole host of bureaucratic roadblocks with the EU, yes?
Of course, misinformation always causes issues.
Now, I'd like to move on to discuss your employment with the defendant, Lush Fertilizer. You are a paid employee for Lush, yes?
I am.
You have been for roughly 10 years.
Going on 12 years now, actually.
And in all that, and so you have a financial bias in the outcome of today's case.
I can guarantee you my salary has not affected my testimony.
But you do have some financial bias in the outcome of today's case.
Some, however, not nearly as much as Dr. Rogers.
Now, I'd like to discuss a study that Lush did. Lush did, in fact, do a study, yes?
We've done several.
There was one done in 2003.
Yes, when Drufo was first being developed.
And since then, Lush has not completed a second study.
Actually, we have completed several follow-up studies. I believe you're referring to safety. And yes, there have been several follow-ups.
Now, the study that I mentioned before has not been replicated, has it?
Actually, it has. We have different scientists within the company look at and confirm the results.
You were not at Lush during the time of this study, yes?
I was not present for the first study in 2003. However, I was present for different later studies.
Yes. Now, going back to the replication of that first study, you mentioned that it was reviewed by several people in Lush. However, that is not actually replication, is it?
You misunderstood my answer, counsel. Those other scientists reviewed and confirmed the data, meaning that they reconducted it to make sure that it was accurate.
So they conducted a second study to confirm this data?
Yes, they did.
You prepared a witness statement for this case, yes?
I did.
This is a true and accurate document?
It is.
You included all information that was relevant in this case?
I did.
And if any new information were to come up, you would update that statement?
That's correct.
So in your statement, it says that the study that Lush did has been replicated?
I did not include any specific details on the replication of the studies, given that I was not present at the company at that time. However, it is company policy.
So that's a no, it is not in your statement?
No, given that I was not at Lush Fertilizer at the time of that study.
Now, after all of the testing that you've done and the research that the people of Lush have reviewed, you cannot say for certain that Drufo does not cause cancer, can you?
I cannot conclude causation in any amount, no, although Drufo has not been linked with non-Hodgkin's lymphoma.
Thank you, Your Honor. No further questions at this time.
Thank you. Mr. Hernandez, do you have any redirect within the scope of the cross?
Yes, Your Honor. May I proceed?
Yes, you may.
Now, Dr. Williams, opposing counsel spent some time talking about the studies that were conducted by Lush Fertilizer. How extreme were these studies?
At Lush Fertilizer, we hold ourselves to the highest standards for both safety and safety of humans and the environment.
And have you replicated these studies?
Of course, while I didn't include in my affidavit that our company follows proper scientific procedure, we do in fact replicate all of our studies.
And how do you account for the differences between the European Union's for fertilizer and the United States?
The European Union has a ban on any new fertilizer components such as Drufo, which are shown in lab settings to put more than incidental levels of nitrates into the soil, which has nothing to do with any possibility that Drufo is unsafe for humans. We are in fact conducting research to show that DRUFO in real world conditions does not contribute nitrates to the soil.
And have you allowed your financial bias to affect you at all in today's case?
No, first and foremost, I'm a researcher and I pride myself on providing accurate scientific data to the public.
Thank you, Your Honor. I have no further questions.
All right, thank you. The witness is excused.
I'm ready, Your Honor. I'm ready, Your Honor.
I'm ready, Your Honor.
All right, thank you. Defendant, you may call your next witness.
Yes, Your Honor. The defense calls Skylar Weirs to the stand.
Mr. Weirs, I remind you that you remain under the oath you took at the beginning of this session.
Yes, Your Honor.
Good afternoon. Please introduce yourself to the jury.
Good afternoon. My name is Skylar Weirs. I'm an investigative journalist for The Rationalist. I'm also Dakota Weir's twin brother. As you can imagine, being called to testify against your own brother has made a hard situation even more difficult.
Now, Mr. Weirs, during your testimony today, we're going to partly focus on your time as an investigative journalist, but also on your relationship with your brother. Now, to begin, let's start with your work. How did you become an investigative journalist?
Well, ever since I was young, I've been fascinated with agriculture and technology, the process we call today modern agritech. Originally, I wrote about it as a hobby, but eventually my work was picked up by a magazine called The Rationalist.
And for us, those of us not common known with The Rationalist, what is it?
The Rationalist is a scientific magazine that seeks the truth, despite the controversies it may create. And to be part of that mission, I've sacrificed a lot.
Okay, so while working at The Rationalist, what types of articles have you researched and published?
Well, originally, I wrote a series on the conflicts between individual health and corporate policy. But more recently, I did an entire series on modern agritech.
And when doing that series on modern agritech, how did you conduct your research?
I try to find everything that's relevant to the topic and my readers. So I'll research everything that I can, including things from companies, research by those companies, as well as independent research. Then I'll cross-reference every single one of those studies to make sure they're reliable and accurate.
Now, Mr. Weirs, when researching modern agritech, did you ever specifically look into Lush fertilizer and its product DRUFO?
I did. Actually, it was one of the first articles that was published.
And what types of information did you rely upon when researching this?
For every modern agritech article I research, I reference tons of information from the USDA and NASDA as they're the most reliable.
Your Honor, at this time, we move to tender Skylar Weirs as an expert in modern agritech.
Your Honor, I believe you are muted.
You are right. At this time, do you have an objection to the acceptance of the witness as an expert in the field of modern agritech?
Yes, Your Honor, I have a voir dire.
Go ahead.
Good morning, Mr. Weirs. You do not have a college degree, correct?
I chose to pursue my career.
So that's a no, you don't have a college degree.
No,
And you don't have any medical training or experience, do you?
I'm not a doctor, counsel.
Exactly, you're not a doctor, so you have no medical training or experience, correct?
Yes,
And you have no personal experience working in the field of agriculture, do you?
no, I do not.
You have no experience working in the field of technology, do you?
I am a journalist. I research these topics, not work in them.
Now, you did not work with your brother at his fertilizer job, did you?
I did not.
You have no personal experience using fertilizers because of your grass allergies, correct?
Yes.
Now, you have only written one article about fertilizer, haven't you?
Actually, counsel, I've written an entire series on modern agritech.
Yes, a series on modern agricultural technology, not fertilizer, correct?
Fertilizers are part of that definition, counsel.
However, that definition includes many other things, doesn't it?
Yes.
Now, you've written one article about Drufo, correct?
Yes.
And this article was written for Rationalist Magazine, correct?
It was.
Now, Rationalist Magazine is not a scientific journal, is it?
It's a quarterly scientific magazine.
So not a scientific journal, correct?
They're one and the same, counsel.
Now, Mr. Weirs, you spent less than a year researching for this entire series of articles, didn't you?
I spent a year of countless hours.
You spent less than a year, correct?
Yes, counsel.
Now, during this less than a year that you spent researching for countless hours, you were also working part-time as a waiter, weren't you?
I was.
Your Honor, at this time, we object to the court admitting Mr. Weirs as an expert in modern agricultural technology, as he has spent very limited time researching this field and has very limited knowledge of it. His knowledge of this field will not aid the jury in any way today, and additionally, it is prejudicial to the plaintiff for the court to qualify Mr. Weirs as an expert in this field because of his lack of qualifications, due to the fact that the jury will place undue weight on his testimony. Mr. Weirs does not have the necessary amount of knowledge, skill, experience, training, or education under Rule 702 to be qualified as an expert in modern agricultural technology.
Your Honor, may I respond?
Yes, you may.
Pursuant to your pretrial ruling in today's case, it was decided that sufficient evidence would need to be laid that Mr. Weirs had reviewed modern agritech, researched publications, cross-referenced these publications, and maintained information from the USDA and NSDA to be qualified as an expert in today's case. As sufficient evidence has been laid for each of these four contingencies, Mr. Weirs has sufficient knowledge to be qualified as an expert in modern agritech in today's case.
May I respond, Your Honor?
Go ahead.
Yes, this pretrial ruling said that in order for Mr. Weirs to be qualified as an expert, he needed to demonstrate that he had spent considerable time reading publications by agritech companies and reviewing all of these publications, researching this stuff, and shows that he has the necessary amount of information to testify to these things. Mr. Weirs has failed to prove that he has any of this experience or knowledge and is therefore not able to be qualified as an expert.
Ms. Burton, do you have a response?
Yes, Your Honor. Mr. Weirs has testified to spending countless hours researching modern agritech, almost a year of his life. He has testified to researching qualified sources of information and cross-referencing them throughout the field. And he has testified to specifically with Lush Fertilizer, referencing information from the USDA and NSDA. Pursuant to this, he has not failed to meet these qualifications outlined in the pretrial ruling.
May I respond, Your Honor?
No, I think I've heard enough. Thank you. I think in deference to the pretrial order, it is plain to me that the witness has satisfied the terms of that order in demonstrating sufficient research into reliable governmental publications that has provided him likely with the knowledge that is sufficient to qualify him as an expert witness. And the emphasis here is on the qualification as a witness, not on the acceptance of what he has to say. I think most of your voir dire, Ms. Abbott, went to the weight or the credibility that one might place on what this witness may testify to. I think that at this point, we're dealing only with his qualification to be accepted as a witness. He's met those standards, and he is therefore accepted by the court to testify as an expert witness in the field of modern agritech. That, of course, does not preclude you from pursuing cross-examination when it is your turn. So, Ms. Burton, go ahead.
Yes, Your Honor. Now, going back to today's case, now that you've been admitted as an expert, what exactly is modern agritech?
Oh, well, in short, modern agritech is the processes, the technologies, and the effects of all modern agricultural products.
So, Mr. Weirs, for those of us not exactly familiar with modern agritech, I just want to lay a little foundation. When researching modern agritech, do you look into specific chemicals in the field?
Yes, I do. Each article that I publish is focused on a specific company, chemical, or a combination of the two.
And when looking into these chemicals or chemical compounds, what exactly do you look at?
Most chemicals come to the rationalist's attention because a concern about their safety has been raised. For a lot of these chemicals, there's some underlying truth to this. However, in the case of Lush fertilizer, there was nothing conclusive I could find.
So you just mentioned Lush fertilizer and concerns being raised. How did these concerns affect the product?
Well, concerns affected the product because other companies were trying to take it down for the same reason that they shouldn't be on the market.
Objection, speculation.
Your Honor, yes, Your Honor. This is not speculation, as Mr. Weirs is only testifying based on his perceptions and observations, based on his research of modern agritech and expertise.
Ms. Abbott?
Your Honor, Mr. Weirs has not demonstrated that he has spent any research regarding other companies and how they might relate to Lush fertilizer. In addition, Mr. Weirs was attempting to testify as to the reasons behind the supposed actions of these other fertilizer companies, which he would have no way of knowing.
Well, Ms. Burton, I think that the objection is well taken in that there has been no testimony that lays a foundation that the witness has done any research into the competitive dynamics that you are seeking to elicit from him. And therefore, I will sustain the objection.
Yes, Your Honor. Now,
Your Honor, I move to strike the witness's testimony from the record.
No, that won't be necessary.
Yes, Your Honor.
Now, Mr. Weirs, what exactly does the rationalist try to combat?
The rationalist's goal is to seek the truth, regardless of what that truth is. So in most cases, it's safety. Sometimes it's competitors. Sometimes it's a combination. Sometimes it's something else entirely.
So does that basically mean it tries to outlie pseudoscience?
Yes, exactly.
And was this a problem with Lush fertilizer?
It was. Other companies tried to attack Lush fertilizer, saying it was dangerous because of—
Objection, Your Honor, speculation.
Ms. Burton?
Yes, Your Honor. Proper foundation has been laid to Mr. Weirs having knowledge of this, as he has researched modern agritech for the rationalists, and the rationalist's main goal is to combat pseudoscience. Therefore, Mr. Weirs, already testifying that he researched Lush fertilizer and did a full article on it, would know the specific pseudoscience that was around this fertilizer at the time, as that's exactly what he was researching.
Response, Your
Ms.
Honor.
Abbott?
Yes, Your Honor, Mr. Weirs has not shown that he has researched at all the competitive field of modern agricultural technology. He has demonstrated that he has researched the actual field of modern agricultural technology and the aspects that fall under that. He has researched Lush fertilizer as in the product. However, he has demonstrated no knowledge of the companies or the competitive dynamics that these companies have, and has no ability to testify as to what these companies are attempting to do.
Well, I think the nature of his testimony was that he had looked into these other companies, or unnamed companies at any rate, and was testifying from his observation of the literature how they were attacking the defendant. Therefore, the objection's overruled.
Yes, Your Honor.
Mr. Weirs, did you get a chance to finish your answer?
I didn't, but in short, other companies were attacking Lush fertilizer because of the fact that it contains nitrogen, but they're just trying to hide that their own products contain even more.
So earlier you mentioned that Lush fertilizer is the safest option on the market. Why is that?
Lush fertilizer is significantly safer than every other fertilizer.
Objection, Your Honor. Improper testimony. This is an expert opinion that Mr. Weirs is not able to testify to, as he is not an expert in a medical field.
Your Honor, may I respond?
In just a minute. All right, Ms. Burton, go ahead.
Yes, Your Honor. Mr. Weirs was specifically testifying to why Lush fertilizer was a safer option because of its chemical makeup. This lies inside the expertise of modern agritech, as Mr. Weirs has been qualified. He was giving no testimony to any medical conclusions of this causing any diseases, for instance. Therefore, this is not an improper expert testimony pursuant to Rule 702.
Well, I think that I agree with Ms. Burton that I didn't hear the question to ask anything about medical safety or medical effects on people. The question was the safety of the product as products as they are used in the environment. And I think he is qualified from his experience and research to testify comparatively as to the modern agricultural techniques of various companies. So the objection is overruled.
Yes, Your Honor.
Mr. Weirs, did you get a chance to answer the question about why Lush fertilizer is a safer option?
I didn't, but Lush fertilizer is safer than all other products on the market for two main reasons. The first is that Lush fertilizer, by containing Drufo, has significantly less synthetic nitrogen, a known carcinogen, in their product than any other fertilizer on the market. And the second reason is that Lush fertilizer and Drufo being an effective bonding agent means that it only needs to be applied twice a year versus other companies 5 or 6 times.
Okay, so now that we've talked about Lush fertilizer and your research in modern agritech, I want to move on a little bit to your relationship with your brother. Now, today you're on separate sides of the case, so why are you testifying?
Many people, including my own brother, think I'm here to testify out of spite or for the inheritance. But really, that couldn't be further from the truth. I love my brother, and if he was blaming the right chemical, I wouldn't hesitate to be his leading supporter.
Now, Mr. Weirs, what was your and your brother's relationship like growing up?
Well, as twins, you kind of get lumped together. So when we were younger, we did everything together. It wasn't until we were about 14 that our lives started to take very different paths.
Now, Mr. Weirs, today we've heard about your brother's work at Haven's Landscaping. Now, before today's trial, as his brother and living with him, did you come to get a general knowledge of what his work entailed?
Dakota worked at Haven Landscaping for many years, and as you said, since I lived with him, I got a pretty good understanding of his work and what company policy was like.
Now, only based on this understanding, what did his work at Haven's Landscaping entail?
From what
Objection, Your Honor. This question calls for speculation.
Ms. Burton?
Your Honor, this question does not call for speculation, as I am only asking the witness to testify based on his perceptions and observations of having a general knowledge of his brother's work from being his brother and living with him.
Response, Your Honor. Mr. Weirs has previously testified that he did not work at this job with his brother, and he has testified that he and his brother had lives that took very different paths when they were 14, which is the time that is being discussed right now. Mr. Weirs has only a very basic knowledge of Dakota Weir's job and is not able to testify to any specifics regarding his job, including what Dakota Weirs may or may not have done at his job, and is therefore speculating.
Well, I think that the testimony that I've heard so far is that because they were living together and because he had spoken with the plaintiff about his job, that he had gained a general understanding. I didn't hear the question to ask specifics, but to ask generally what the job entailed. And for that reason, I'm going to overrule the objection.
Yes, Your Honor.
Yes, Your Honor. Now, only based on your knowledge, did you get a chance to finish your answer?
I didn't, but based on what I've heard, I know that Dakota worked as a landscaper, basically meaning he spread many harmful chemicals on a daily basis.
Now, Mr. Weirs, you've been present for all testimony today, correct?
Yes, I have.
Now, earlier we heard from Dr. Rogers that she didn't review the other chemicals your brother worked with. From your own research of modern agritech, why is this concerning?
Objection, Your Honor, leading.
Could you rephrase the question, please?
Yes, Your Honor. Now, based on what we heard from Dr. Rogers, is her not looking into other chemicals concerning?
It is, especially because other chemicals on the market are just so much more dangerous than Lush because of the amount of synthetic nitrogen they contain. Without knowing the side effects, you don't get the full story.
Now, Mr. Weirs, I want to talk about the chemical in today's case, Lush fertilizer. I'll have my trial technician pull up Exhibit 1. Now, at the top in the hazard section, it says keep out of reach of children. How old was your brother when he worked at Havens Landscaping?
When Dakota started working, he was only 14, just a child.
So does that mean he misused this product by not following that recommendation?
Yes, he basically ignored the warning and just didn't use the product correctly.
Objection, Your Honor, speculation.
Well, I'm sorry. Could the witness restate his answer so I can hear it?
I said that Dakota didn't work with the product correctly, being only 14, and it's saying to keep out of reach of children.
Okay. And your objection, Ms. Abbott, is speculation?
Yes, Your Honor.
All right. Ms. Burton, do you have a response?
Yes, Your Honor. This is not speculation, as Mr. Weirs is only testifying based on his expertise in modern agritech and the specific recommendations on the packaging. By being an expert in modern agritech, Mr. Weirs would know what the general guidelines are for keeping out of reach of children in this specific context, and knowing that his brother started working there at 14 would know if this went against the specific recommendations on the packaging.
Response, Your Honor?
I don't think I need a response. I think that this is sort of a tempest in a teapot, because there's nothing that requires expertise to respond to a question whether a 14-year-old is complying with a statement on a label that says keep out of reach of children. I don't know that you can actually make any conclusions from that, but it doesn't require expertise and it doesn't require speculation. So overruled.
Yes, Your Honor. Did you get a chance to finish your answer?
In summary, Dakota didn't use the product correctly by being only 14 and working with it saying keep out of reach of children.
Now, moving down to the user safety recommendations, it says with any spray fertilizer, utilize protective clothing that covers exposed skin and use respirator or N95 face mask. Based on your knowledge of Dakota's work, did he do this?
As far as I could tell from what Dakota told me, Haven Landscaping never trained him to use protective gear.
Objection, Your Honor, speculation.
Ms. Burton?
Yes, Your Honor. This is not speculation, as once again, I only asked the witness to testify based on his own observations and perceptions of his brother's work experience from having that general knowledge of living with him and talking to his brother about his work.
Response,
Ms.
Your
Abbott?
Honor? A general knowledge does not include specifics of Dakota Weir's work, such as whether or not he wore a specific type of mask or specific types of clothing. A general knowledge would only include things about what he did generally, and therefore Mr. Weir's attempting to testify as to the specifics of Dakota Weir's actions regarding what he wore are therefore speculation.
Okay, well, I'm not sure why we're trying to deal with this, since earlier today the plaintiff himself testified that he didn't always wear a mask and he didn't always wear clothing that was consistent with the recommendations. Specifically as to the objection, the question was based on his conversations, the witness's conversation with the plaintiff, did he comply with this recommendation? And based upon the conversations, which would be an admission of a party, he can answer that question. So overruled.
Yes, Your Honor. Now, Mr. Weirs, is this other misuse concerning?
Yes, but not for the reason you think. Dakota misusing Lush is a problem, but Lush is safe. The problem comes with these other dangerous chemicals that he didn't wear protective clothing for either.
Thank you, trial technician. Exhibit 1 can be taken down. Now, Mr. Weirs, we've talked about the misinformation about Lush fertilizer and your brother's misuse of modern agritech chemicals. Based on that, is today's lawsuit misguided?
Absolutely. The fact that Haven Landscaping made my brother work with products that said keep out of reach of children on various other warning labels is extremely concerning. And blaming Lush, the safest product on the market, just doesn't make sense.
Thank you, Your Honor. I have no further questions at this time.
Thank you, Ms. Abbott. You have cross-examination.
Yes, Your Honor. Good morning again, Mr. Weirs. I would like to begin by talking about your experience with the chemical Drufo. The article you wrote about Drufo is not peer-reviewed, is it?
It is researched on peer-reviewed studies and peer-reviewed conductations of research.
Mr. Weirs, that wasn't my question. I asked you if the article you wrote was peer-reviewed, and it sounds like the answer is no. Is that correct?
All the research was the actual article, no.
Now, this article is the only publication about Drufo that you have authored, isn't it?
Yes.
And as part of your research for this article, you didn't conduct any tests or experiments using Drufo, did you?
No, I relied on the experts who did.
Mr. Weirs, I want to make sure I understand your research process for this article. You read information from government sources and publications from agritech companies, correct?
As well as independent studies, yes.
So all of your research for this article came from reading other people's studies and publications, didn't it?
Yes.
Now, Mr. Weirs, I'd like to talk about your motivations for testifying here today. You have gambled for years, haven't you?
I've done a little sports betting, counsel.
For years, correct?
Yes.
And you have been in debt for years because of this, haven't you?
I got into debt in a March Madness tournament, yes.
Years ago, correct?
A couple years back.
And you are still in debt because of this, aren't you?
I am.
And your father cut you off financially after your brother's cancer diagnosis, didn't he?
My father never paid me for my gambling debts.
But you were cut off financially completely, correct?
Yes.
And your career as a journalist is not lucrative, is it?
No journalists is.
Thank you. You have no further questions.
All right. Ms. Burton, do you have any redirect?
Yes, Your Honor, briefly. Before I begin, could I get a time check from our trial technician?
Go ahead.
You have 6 minutes and 36 seconds remaining.
Yes, Your Honor. Now, Mr. Weirs, opposing counsel just talked a lot about peer reviews. Is it common for rationalist articles to be peer reviewed?
The articles themselves aren't peer reviewed. However, all the research that is referenced is.
And did bias for money gain have anything to do with your testimony today?
Actually, if Lush wins this case, I stand to lose money. So no.
Thank you, Your Honor. I have no further questions.
All right, thank you. The witness is excused.
I'm ready, Your Honor.
I'm ready, Your Honor.
I'm ready, Your Honor.
All right, thank you. Defense, you may call your next witness.
Yes, Your Honor. The defense calls Blake Dawnport to the stand.
I remind the witness that she remains under the oath taken at the beginning of these proceedings.
Yes, Your Honor.
May I proceed?
Yes, you may.
Good morning. Please introduce yourself to the jury.
Good morning. My name is Blake Doncourt, and I'm the CEO of Lush Fertilizer. I want to say that it is a tragedy what has happened to Mr. Weirs, and I wish him a speedy recovery. And it's precisely because of that that I founded Lush Fertilizer.
For the record, have you been here throughout the trial today?
Yes, I have.
Is there anything in particular that struck you about the testimony of Mr. Dakota Weirs?
While I knew that Mr. Weirs was using fertilizers and other chemical products, I'm concerned that even now we still don't have a list of those chemicals or possible side effects from them.
Why is that concerning?
As you've heard throughout today's trial, there are products out there that do have serious health and environmental effects. That's really why I started Lush Fertilizer.
Can you elaborate on that?
I wanted to create a revolution in the agri-tech industry. I saw that there were products out there with dangerous health effects and that it was destroying our environment. So I started work on Drufo, and it solves every one of those problems.
How did you begin creating a product like Drufo as a young entrepreneur?
We had to start by synthesizing the compound itself. After years of research and development and countless late nights and a significant amount of capital, we finally had a product ready to bring to market.
You mentioned research and development. Did that include any kind of safety testing?
Absolutely. I would never put a product to market if I had any doubts about its safety.
To your knowledge, did any of that testing ever show a link between using Drufo and getting cancer?
Not only did none of our internal studies identify cancer as a risk from our product, but there are in fact no conclusive studies showing a link between use of Drufo and cancer in humans.
Earlier, we heard some of the concerns of Carson Durst. Were you ever made aware of these concerns?
No, I wasn't. Ms. Durst had every opportunity to bring any concerns she had to her direct supervisor, Jerry, or to my attention directly. In fact, that was her job. She never did any of that and never made me aware of any concerns.
We also saw an email that was supposedly sent from upper management to other employees at the company. Was this email ever actually sent?
No, it wasn't. I never received such an email, and that's rather surprising since I'm supposedly a recipient of that email.
To your knowledge, was Drufo and Lush Fertilizer within all federal regulations?
We met and complied with all federal standards to ensure that our product was safe and so that it could be sold in the US market.
Now, even though your tests were negative regarding carcinogenic effects and you met all of the federal regulations, did you still put warnings on the packaging of your product?
Yes, there are several warnings on our product.
Now, based on these warnings, did you hear Dakota say that he didn't follow the warnings?
Mr. Weirs absolutely did not follow our warnings. We say very explicitly to wear protective clothing covering exposed skin and to wear an N95 rated respirator. We also say specifically to keep out of reach of children. Not only did he misuse our product, but he misused every product that he worked with while at Havens Landscaping.
Should he have even been using the product in the first place?
No, he shouldn't have. Like I just said, we explicitly say to keep out of reach children. Havens Landscaping shouldn't have been hiring children to work with these chemicals, and they should have been monitoring their employees to make sure that they were following the recommendations laid out on the packaging.
So how do you feel about the allegations that have been made against your company?
The allegations made against my company are predicated entirely on misinformation. We conducted test after test, and all of them showed that our product is safe.
We've talked about Dakota's misuse of the chemicals you worked with.
And you've also talked about the misinformation about your company. So in your opinion, is this lawsuit misguided?
This lawsuit is entirely misguided. You've heard today all the safety testing that we did and all the research that shows that our product is safe. And there's absolutely no way that Lush Fertilizer is responsible for Mr. Weir's cancer.
Thank you, Your Honor. I have no further questions at this time.
All right, I'm sorry. Go ahead, Ms. Eisner. You have cross-examination.
Good morning, Mr. Doncourt.
Morning.
I'd like to start by talking a little bit about your product, Lush Fertilizer.
All right.
So you consider your company to be very thorough in its product research, yes?
We conduct all necessary testing to ensure that our product is safe.
And yet you did not put a warning label on your products that contain Drufo.
There was no need to put a warning label.
So no, you did not put a warning label on your products containing Drufo.
Like I just said, there was no need, so no, we didn't.
And in fact, you do not put warning labels on any of your products?
Considering that all of our products are safe to use, no, we don't.
Now I'd like to turn your attention to a former employee of yours, Carson Durst. So you hired her to work at your company, correct?
And Ms. Durst was first brought on as an intern back in 2003.
But yes, you hired her to work at your company.
Yes,
And she worked with you for some time,
about 3 years.
and she was even promoted rapidly through your company,
She was?
and she was fired only after the time of the Drufo study.
Yes, she was.
Now I'd like to talk about your company's decision not to bake your product. So you did not bake your product, correct?
We do not bake any of our products as all of our tests showed that it wasn't necessary.
So no, you did not bake your product.
No, we do not.
But you knew that baking the product would have made it safer.
Our product was already safe.
But just to clarify, baking the product would have made it safer.
Baking the product would have only removed the risk of carcinogenicity. There was no risk of carcinogenicity.
So baking the product would have removed any risk that your product was possibly carcinogenic.
But there wasn't that risk, so it wasn't necessary.
However, you knew that baking the product would have removed any possible risk if it existed.
Had the risk existed, we would have baked our product.
But that is still a yes to my question.
Yes.
Now, I would like you to reference your copy of Exhibit 8.
Right.
So this is a copy of an amortization report, correct?
Yes, an amortization table I made back in 2004.
And when you made this table, you were the CEO of Lush?
That's correct.
And this is a complete and accurate copy of that table?
Yes, it is.
Your Honor, I move to enter Exhibit 8 into evidence.
Is there an objection to the admission of Exhibit 8?
I have no objection, Your Honor.
Then Exhibit 8 is admitted into evidence.
Permission for co-counsel to publish this exhibit via screen sharing.
Granted.
Mr. Doncourt, I'd like to direct your attention to the column titled Estimate Profit Increase. So
Right.
It's true that your profits would have increased by 6% in the first year that you did not bake your product, correct?
Yes, that's correct.
And they would have continued to increase by 2% every year thereafter?
That was our initial prediction, yes.
Now I'd like you to look at the estimate overall revenue loss column.
Okay.
So you would have lost $250,000 in the first year that you baked your product, yes?
That was what was predicted, yes.
And by 2014, you predicted that you would have lost over $2.6 million.
That was the prediction, yes.
So you admit that you thought baking your product would be expensive.
It would have been, and it would have been extra expensive considering it wasn't necessary.
So just to clarify, that is a yes to my question?
It was expensive and it wasn't necessary, so we chose not to.
You also needed that money to pay investors, right?
No,
No, you did not need that money to pay investors?
no, we had plenty of profit to pay our investors.
But paying your investors was a responsibility of your company,
That was a responsibility that was taken care of.
yet you still needed money to pay your investors, correct?
No, that was already taken care of.
But your investors were pressuring you to give them a good return on their investment, right?
Which we were doing, like I just said, we were taking care of it.
So that is a yes, they were pressuring you.
To a degree, but they had no impact on this decision.
You do say that baking your product would have been too expensive for the risks it would remove, yes?
For the little risk that it would have alleviated.
So that is a yes to my question?
For the little risk that it would have alleviated, it just wasn't necessary. So yes, it was too expensive.
Thank you. No further questions at this time.
Thank you. Is there a redirect to the scope of the cross?
Yes, Your Honor.
How much time do you have left?
You have 1 minute and 18 seconds remaining.
Thank you. Go ahead.
Yes, Your Honor. Mr. Doncourt, why did you decide not to bake your product?
Like I said, the product would have only needed to be baked had we found risks of carcinogenicity. All of our tests showed that there wasn't that risk, so it wasn't necessary.
Now, if my trial technician could pull up Exhibit 8, and if you could reference that in front of you, Mr. Doncourt. What was your estimated net profit in the first year?
$1,675,000.
Would that have been enough money to adequately pay all of your investors?
Yes, it would.
Would it have been more than enough?
Yes.
Thank you, Your Honor. I have no further questions.
All right, thank you. The witness is excused.
I'm ready, Your Honor. I'm ready, Your Honor.
I'm ready, Your Honor.
All right, thank you. Does the defense have any additional witnesses?
No, Your Honor. At this time, the defense rests.
Thank you. And we are ready for closing arguments. Plaintiff, are you ready?
Yes, Your Honor. Before I begin, I would like to renew my request that any remaining time at the end of my closing argument be reserved for rebuttal.
That is granted.
Yes, Your Honor.
Go ahead.
Members of the jury, this is a case about a company that cared too much about their wealth to take the necessary precautions to keep their customers safe and the devastating repercussions of this negligence. Mr. Dakota Weirs has non-Hodgkin lymphoma, an incurable form of cancer that has utterly and permanently derailed his life, robbing him of his future. And the cause of this cancer? A chemical manufactured by Lush Fertilizer. This chemical did not have adequate safety warnings, was not prepared in a safe manner, and contained a carcinogen, the chemical Drufo. Lush Fertilizer knew that their product could cause non-Hodgkin lymphoma and still made the decision to protect their profits at the expense of the health of customers like Mr. Weirs, putting their profits before people. Today, the plaintiff had to prove that the defendant was negligent in creating a product that would keep its users safe, and through this negligence, caused Mr. Weirs suffering. We had to prove this by preponderance of the evidence, meaning that in order for you to find in favor of Mr. Weirs, you only need to think it is slightly more likely than not that the defendant's negligence caused Mr. Weirs damages. Members of the jury, we have proven this without question. You heard that Drufo causes cancer from Dr. Casey Rogers. Her years of performing experiments to understand the effects of chemicals on the human body and her access to Dakota Weirs' employment and medical records have given her unparalleled knowledge of this case and this product. As she told you, her study found that non-Hodgkin lymphoma is 10 times more common in individuals who've been exposed to Drufo than those who haven't. It's her expert opinion that Drufo was the direct cause of Dakota Weir's cancer. You also heard that many employees of Lush Fertilizer were aware of Drufo's carcinogenic properties. Ms. Carson Durst, a former Lush employee, testified that numerous high-ranking officials at this company were aware of the in-house study that raised concerns that Drufo causes non-Hodgkin lymphoma. Lush attempted to silence Ms. Durst by covering up her evidence, the deleted email. You also heard the CEO of Lush admit that they didn't take the simple safety precaution of throwing their fertilizer in an oven because it was just too expensive in their minds. You also heard from Mr. Dakota Weirs himself, who told you of the horrors of this disease and how it has completely destroyed his life. He told you how he's lost his ability to play the piano. He told you about the weakness and horrendous pain he experiences every single day. He told you about the devastation that Lush Fertilizer has brought on him through their negligence. Lush Fertilizer put profits before people repeatedly, and Mr. Weirs has suffered for it. Lush Fertilizer refused to put adequate warning labels on their product, refused to bake it to prevent any carcinogenic properties, and then sold the product anyways. Nothing can give Mr. Weirs his life or his health back. But you, jury, have the ability to compensate him by making the defendant pay him non-economic damages for the physical and mental pain and suffering, impairment of the quality of life, and emotional trauma and distress that he has experienced. How can you assign a value to Mr. Weir's suffering? It's an almost impossible task. Is it worth $1 million, $3 million? Or maybe you should award him the amount of money that Lush Fertilizer chose to increase their profits by when they chose not to bake their product, $2.6 million. Regardless of your choice, the evidence has shown that Lush Fertilizer's negligence caused Mr. Weir's cancer. We are asking you today to ensure that Lush Fertilizer is held accountable for what they have done by ensuring that Dakota Weirs is compensated for the trauma he has endured, and that you hold this company accountable for putting profits before people. Thank you.
Thank you. Timekeeper, what is the time remaining?
I have 38 seconds, Your Honor.
38?
Yes, Your Honor.
All right, thank you. Defense, you may make your closing argument.
Yes, Your Honor. May it please the court?
Go ahead.
Misguided, misinformed, and misused. Lush Fertilizer does not cause cancer. By now, that much should be very clear. Lush was created to provide a safe alternative to the products made by the nefarious giants of the agritech industry. Now today, the plaintiff tried to tell you that Lush put profits over people. But you heard just the opposite. Lush Fertilizer started out small and has always been mission-oriented, being committed to their customers. You heard about the extensive research and testing they put their fertilizer through, and you heard that it was never meant to be used by children, let alone in the way that Dakota used it. Today, the plaintiff's case is misguided, misinformed about the pseudoscience presented as fact, misguided about the true effects of Drufo, and based on the plaintiff's misuse of Lush Fertilizer, well, he was just a child. Now, in today's case, we do agree with what some of the plaintiff has said. We agree that Lush Fertilizer contains Drufo, and we agree that this, Exhibit 1, is the product label. But most importantly, we agree that what Mr. Weirs has gone through is a tragedy that no person should ever have to experience, but it ends there. Because we didn't cause Mr. Weir's cancer, other fertilizers did. The first place to begin today is determine whether the plaintiff has met their burden. Because if they have not met their burden, then you do not need to go on to determine whether we have met ours. Jury instructions number 2 and number 3 outline this burden, which they had to prove by a preponderance of the evidence. However, they failed to do so for 4 main reasons. 1, they did not and could not provide a link between non-Hodgkin's lymphoma and Lush fertilizer. 2, people who work in the modern agritech industry are reasonably expected to know the products they work with are dangerous. 3, the product was not used in a reasonable manner. And 4, it was never meant to be used by children. Keep all of this in mind when determining your verdict today, but also ask yourself these questions. The plaintiff never provided a list of the other chemicals Dakota worked with or even researched their effects. Why? They never called another employee from Havens Landscaping to talk about company procedure or conduct. Why? And this is the first time in 15 years that Ms. Durst is ever bringing up concerns. Why? Even if you find that the plaintiff has met their burden, the second step is to go on to determine whether Dakota's own negligence contributed to his condition today. Jury instructions number 8 and number 9 outline this burden, which we have proven by a preponderance of the evidence for 2 main reasons. 1, Dakota ignored safety guidelines at Havens and didn't follow recommendations on Lush Fertilizer's packaging. And 2, even the plaintiff's own expert witness recommends wearing protective clothing when working with the product and even said it's reasonable today in court. At the end of the day, Lush Fertilizer does not cause cancer. They never put profits over people and have always been committed to their customers, doing the necessary testing and would have baked their product if it was necessary. At the end of today's case, sign your verdict form affirming the plaintiff did not meet their burden and find Lush Fertilizer not liable. Thank you.
Thank you. Ms. Eisner, you have 38 seconds if you want to use it for rebuttal.
Yes, Your Honor. Thank you. Members of the jury, Ms. Burton just tried to tell you that today's case is about being misguided, misinformed, and misused. And that is exactly right. The defendant is misguiding the jury with their attempt to blame a 14-year-old kid for getting cancer. Lush Fertilizer misinformed their customers when they refused to put accurate safety warnings on their product, just so that they could line their pockets. And Lush Fertilizer misused their power as a company by selling a dangerous product for profit. We are asking you to hold this company accountable for refusing to keep their customers safe and putting profits before people. Stop. Thank you.
Ms. Abbott, thank you. All right, the case stands submitted. The judges are going to fill out their scorecards. I'll remind them to put their telephone number on it. Make sure you submit it.
I don't know if this announcement is required, but I have submitted my scores.
All right, thank you. Good.
I've submitted, Your Honor.
All right, thank you. Then we're going to have a certain amount of time while the central office reviews them and makes sure they're complete. And during that time, while we're waiting, there's an opportunity for the scoring judges to give some feedback to the teams. I think that this was a very intensely argued and well-presented session of this case. I thought both teams were very well prepared, had thought through the problem very well, and gave a very intense and interesting presentation of the problem. So scoring judges, if you have any other comments you would like to make, starting with, I guess, Mr. Lambert.
Yes, can everybody hear me?
Yes.
Good. So I think that especially the opening statements were particularly good. It's good to sort of have a narrative and a theory of the case. Thought there were good use of at least what I refer to as head notes and a roadmap. I thought especially good was the explanation at the end of the defense's opening that of the burden of proof. That's especially important to have, especially when there are jurors in a case. The only other thing I would sort of note is that I thought there was a good, especially good and exceptional knowledge of the technical information in this case. These cases can be particularly difficult, especially for witnesses, because it is a very sort of technical analysis you have to get into. And I thought that the expert witnesses in particular had a very good grasp of the technical information in this case.
Thank you. Ms. Haywood?
Hi, yes, I just want to congratulate everyone who participated today. And I echo what Ms. Lambert said, that your cases were very thought out. It seemed clear that everyone had a very strong knowledge of the case and the roles that you were playing. And the witnesses were really informed and did some great acting. So it was very enjoyable to watch. And thank you again. Great. Good luck.
All right. Thank you. Ms. Moss.
Hi. So as the other two said, I'll echo that everyone did an amazing job and y'all clearly know this case really well. And I was, particularly impressed with the experts. And I remember from mock trial, being an expert has a lot of pressure to it because you have to remember a lot of things. One thing that stood out to me that I did want to just point out, and I'm actually going to just invite you all to correct me if I'm wrong on this, but my notes from the beginning had Team Stanley requesting admission of Exhibit 1 by stipulation, and Team Meredith objected. And so I believe that was the plaintiff objecting to that stipulation. And then I noted in the first direct examination of Dakota Weirs, plaintiff was the first one to offer Exhibit 1. And so I was a little bit confused on why the plaintiff objected to that exhibit being stipulated to when they were then intending to use it. And I don't know if that was a requirement by the rules necessarily, but that was a little bit confusing to me. But aside from that, everyone did an amazing job. And congratulations to everyone just for getting through all of this.
Okay, I think if I could clarify that, one, that kind of business between the parties as to what is going to be stipulated and what is not going to be stipulated in the normal course would be done outside the presence of the jury. So you would not have been confused by the back and forth on that. And substantively, it was the plaintiff's position that the rules required that exhibits be introduced, authenticated, and accepted by the court during the course of trial. And that was the nature of their objection or decision not to stipulate to it. And that is a matter that's within their competence and within their decision as to whether to waive that rule or not. They chose not to, and that was fine. Again, I think all of you did a really good job. I enjoyed it, and I wish you all very good luck going forward. Thank you.
Thank you, everybody.
And I think before we go, I think we have to get from the powers that be confirmation that the scoring sheets have been submitted and accepted. So they have been, then okay, we are done and we are good to go. Thank you very much. Get some lunch. Good luck this afternoon.
Thank you.
Thank you.
Thank you.